By the way, this court has made an order premised on the basis that you did not oppose the application. You actually suggested that maybe if we postpone it to Thursday, you remember?
Yes.
Saying that.
Well,
Hello?
yes. No, that was in respect of legal aid, my lord. That
No, it wasn't.
the issues pertaining to legal aid be stood down. So for a few days, my words were, my lord, that the issues regarding legal aid be stood down so that this issue can be resolved. And I did mention, my lord, that precisely what Mr. Ramusipili has put on record now, that we might find ourselves in a situation where accused number one is not in the position to afford legal fees.
So you're saying the order made was incorrect?
Well, I'm just putting on record what
the state's view.
What the state view was. The court will recall that even when we were in chambers, I indicated that the state opposes the application, and the state and the court then mentioned to Mr. Ngomezolo that the state is opposing the application. What is his comment?
No, fine. I'm overruling you. I've made an order, and I understood the order to say that the application for the reopening of the accused one state's case, number one's case, is granted. The order is granted.
We do understand and respect that, my lord, but can we just be allowed to argue the point? And if the court then still, after arguing the point, overrules us, we'll leave it there. But
okay, let's hear you.
We just ask to be heard, my lord.
Okay.
We've compiled heads of argument, my lord, in this regard. My lord, the nub of the issue at this stage is whether accused number one can be allowed to reopen his case and call further witnesses in a trial within a trial after his legal team, consisting of Mr. Ramusipili and Mr. Ngomezulu, took a conscious decision to close the defense case on the 16th of February 2024 without calling any defense witnesses. In paragraph 1.2, my lord, we point out that Mr. Ramusipili has been representing accused number one and two during the trial. On the 16th of October 2023, Mr. Ramusipili indicated to the court that Mr. Ngomezulu was joining him as part of the defense team for accused number one and two. And he addressed the court as follows. We refer to the record of the 16th of October 2023, pages 1 and 2. And we quoted the following passage. Mr. Ramusipili, as the court pleases, my lord, I'm indebted to the court, my lord. I'm here to introduce and appoint Mr. Ngomezulu, who is part of our team, the defense for accused 1 and 2, and he will be dealing with the evidence regarding the aspects that we are covering from Friday and also in the future, my lord, as the court pleases. And then the court remarked, yes, Mr. Ngomezulu. Then Mr. Ngomezulu replied, as the court pleases, my lord, it is indeed so that I was instructed by Advocate Ramusipili to come. Then the court asked him, is Mr. Ramusipili an advocate or attorney? Then Mr. Ngomezulu replied, he's an attorney. Then the court remarked, he cannot appoint another advocate. Then Mr. Ngomezulu replied, I beg your pardon. Then the court remarked, only an attorney can do that. Then Mr. Ngomezulu replied, I beg your pardon, that is indeed so, my lord. I request that I'm ready to proceed. The court said yes. Then Mr. Mgumezulu, as from tomorrow, as arranged in relation to the evidence of the magistrate. And the court said yes. Then Mr. Mgumezulu, I was going to bring an application for the recalling of Colonel Mboto, who has already testified on Friday, together with Sergeant Monareng, on the instructions that I got from accused number 1. I humbly request the court, my lord, that I need to consult with both accused 1 and 2 and request the honorable court to make an order that I be given some few hours to consult with accused 1 and 2 as it pleases the court. So, my lord, we make the submission that Mr. Mgumezulu has been part of the defense team for accused number 1 and 2 as early as the 16th of October 2023, in the early stages of the trial within the trial. It was put on record, my lord, when we were here on Monday, on the 4th of March, that the defense team for all 5 accused met to discuss whether the witnesses or some of the witnesses that Mr. Mgumezulu mentioned should be called on behalf of the accused. And after that meeting, a decision was then taken by the defense counsel, of which Mr. Mgumezulu was part, not to call those witnesses. Now, Mr. Mgumezulu wants to call those witnesses after counsel had submitted heads of argument on the matter. If this application to reopen the case for accused number 1 is granted, new evidence will be adduced, which means that all counsel will have to revise their heads of argument to include the newly adduced evidence. In paragraph 1.4, we point out that when the trial resumed on the 4th of March 2024 for argument on the admissibility of the statement made by accused 1 and 2, Mr. Mgumezulu indicated that he has not been paid by the Legal Aid Board and that he now holds a private brief to represent accused number 1. He also signaled his intention to apply for the reopening of the case for accused number 1 in the trial within the trial in order to call further witnesses. In paragraph 1.5, we point out that the state objects to the reopening of the case for accused number 1 to call further witnesses. Firstly, the reopening of case is not merely there for the asking, as we've pointed out. Mr. Mgumezulu must bring an application for the reopening of case for accused number 1. Then we deal with the legal position, my lord, in paragraph 2.1. The question that must be asked is whether the right to a fair trial in terms of section 35(3) of the Constitution includes the reopening of a defense case after a conscious decision was taken not to call the witnesses that are now being sought to be called. We refer to the legal classicals on fairness of a trial, which is now entrenched in section 35(3) of the Constitution. And the court has repeatedly referred to this case of R versus Hepworth, 1928, AD 265, at 277, wherein the court held, and we quote, that a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side. A judge's position in a criminal trial is not merely that of an umpire to see to it that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice is done, and we close the quotation. We refer further to this case of State versus Sheikh and others. The citation is given in the heads, wherein the court held as follows, and we quote, the applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extend beyond those specific rights enumerated. in subsection 35(3)(a) to O of the Constitution, the right to a fair trial requires a substantive rather than a formal or textual approach. And this is the point that we want to emphasize, my Lord. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime, we close quotation. We refer further to the case of Multi-Choice Limited and others versus the National Prosecuting Authority. We give the quotation there where in the SEA, per the now JP of the Gauteng Division, he was then the judge of the Supreme Court of Appeal, had as follows, and we quote, "Our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has a constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial." And the court then referred to the case of Zukuz and others, State versus Chilo, wherein they described the right to a fair trial as follows: a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial, and what infuses its purpose is for justice to be done and also to be seen to be done. Then we refer to the case of State versus Lameni and others. We give the quotation there where Judge Krichler, as he was judge of the Constitutional Court, described the phrase "interest of justice" as follows: as a useful term denoting, in broad and evocative language, a value judgment of what will be fair and just to all concerned. Then we refer to the handbook Himstra on criminal procedure, the February 2023 version at pages 22 to 16. There, my Lord, he sets out the principles that are applicable to the state insofar as reopening of its case is concerned, but we submit, my Lord, that these principles are applicable in equal force to the reopening of the case by the defense. The writer states as follows: once the state case has been closed, it is possible for the state only, and we emphasize it, my Lord, only in exceptional circumstances to lead further evidence. Such circumstances include being surprised by the new fact which the state could not have foreseen. If there was an indication of the facts, whether in plea explanation, cross-examination, or in other manner, the state has to lead evidence in rebuttal before closing its case. So, my Lord, we're saying the defense has been aware of the issues that are in dispute in this matter, and before closing their case, they should have made sure that they lead all the evidence. Paragraph 2.6. My Lord, we mentioned that the possibility of calling those or some of those witnesses was discussed amongst the defense counsel, of which Mr. Mgomezulu was part, and a conscious decision was taken not to call them. There's thus no element of surprise, and we also submit, my Lord, that there are no exceptional circumstances for the reopening. We submit that the defense must lead all its witnesses during its case, and that a conscious decision has been taken not to lead evidence of those witnesses during the trial within the trial, but that they will consider calling them in the main trial, and Mr. Mgomezulu agreed with the decision. Paragraph 2.7, we submit, my lord, that an important factor to consider is that some of those witnesses might be on the list of state witnesses in the main trial.
Yeah, sorry, that's exigency. Is that a fact? You remember
Yes,
I asked,
it is a fact. For
I
instance,
asked,
yes.
if you recall, who are these witnesses?
Yes.
Mr. Mgomezulu said, hey, SAP.
Yes.
I said, who? Then he elaborated and mentioned their names. He knows the principle. If any of those witnesses who are police officers are in the list of witnesses intended to be called by the state, you know the first privilege and preference falls onto the state, Mr. Mgomezulu.
Yes.
You are aware of the principle.
Yes. For instance, General
No,
Shabani.
let him
Yes.
first
Oh,
respond.
sorry.
Because that is the only factor which is new here. That, let's read it so that, an important factor to consider is that some of them might be on the list of state witnesses in the main trial. For instance,
Yes.
General Shabani, so the state must still make a call whether to call him or not. He is thus a state witness. What do you say about that?
My Lord, I agree with the court to the effect that if a witness is purported to be used in the main trial, the state must be, in the event does not want to use that witness,
Yeah.
can make the witness available
Right.
to the...
What's the section 2? Who knows criminal law here? Section, when you make witnesses available, you don't just make them available. The law
Yes.
says so. Section?
I think it's 2.
Okay, fine.
Yes.
Right, yeah, you know that.
Yes, my Lord, I know that.
That's it. So,
My Lord,
no, just listen to me.
all right.
You must confer with Mr. Baloyi about the possibility of, for instance, this very witness, Shabani, whether he intends calling him. I made a considered decision. And you know, by the way, I'm functus officio.
yes.
You know that.
That's
I've made
correct.
that decision. I can't go back. But this exigency was never considered by me. I consider the fact that there were exceptional circumstances in calling these so-called 3 witnesses by accused number 1 in rebuttal of the state's case in the trial within the trial, because it was never mentioned at any stage. You and Mr. You and the other defense counsels, you held a private meeting. Is that not so?
That's correct.
I wasn't part of that meeting. So I wasn't aware that, oh, zombies are going to the main trial or what. So I just listened to you saying that it is imperative and in the interest of justice and fairness that those witnesses required for the defense of accused number 1 be called, right? So I don't have a problem with that. The only problem which would appear to be a problem is if General Shabani, as stated by the state, is intended to be used in the main trial.
May I address the court?
Yes, yes.
My Lord, in relying on the exceptional circumstances that may emanate during the application or at the request of either of the party, it has been made clear that General Shabani does not have to come and testify on what the state will lead as evidence in the main trial.
Who says that?
That's what I told my colleagues.
Who told you? I
May I-
don't know that.
Yes, may
I
I,
don't know that.
may I address further?
Yes.
Accused number 1, when he places the evidence, when he led his evidence, he said when he was released, then that was said during the course of the trial within the trial. And I even, when consulting with General Shabani, I only
No, I don't
on
want to
that
hear
aspect.
no, I don't want to hear about your consultation.
Yes.
You know it's improper.
But I don't want to dwell much on the consultation.
No,
The
no,
reason why.
No, you know what? There's only one aspect here. Whether Lishabani is going to be used in the main trial or not. That's all. The other stories, they're settled. I've given an order that you can call whichever witnesses you want to call.
Will the same
But
apply?
if the state says one of the witnesses it wants to call, then the law obviously says the state must have the first privilege to call that witness. And if he refuses, Mr. Balui, if he refuses after having made a statement, you know what to do.
Yes, there are various
Yeah, the law is
avenues
clear.
open. Yes.
You can be impeached,
But
etc., etc.
what puzzles me is that the same state that is objecting to the calling of General Lishabani is the one that subpoenaed him to come to court today. So if this thing is canvassed now and I was not informed,
Yeah, okay, now that
Advocate Baloi.
Mr. Gomez, otherwise we're going to be here the whole day.
yes,
Unless you quote me the law which says I can override the consents of the state that they intend calling Lishabani. If it's in the law, I will order it, okay?
thank you, my lord, I will do so.
Otherwise,
But may I just
Sisi-
place
Sisi
this
Kulengo,
one, because
man.
the state has already made submissions relating to all what the court has
To what?
had. I'm saying the state has already made submissions
to do what?
about these heads of argument, and I was not even informed that they are going to.
No, they're irrelevant now because like I said,
They are relevant, but I was not afforded the
Yeah, fine.
opportunity, and I did not consult with accused number
They're
one.
fine.
Yes.
But those hits, they're okay. The only new dichotomy which they traverse is the fact that Lishabani may possibly be called by the state as a witness in the main trial. That's all. Otherwise, all these principles, I know them. One case you, Mr. Baloi, forgot is State versus King. Hello? Are you aware of that
Yes,
case?
indeed, my lord.
That's it. That's the leading case in this exigence.
Yes,
SCA. Judgment was written by Harams.
yes. But
Okay.
can we
So,
just
okay,
maybe,
lo mthetho ngiyawazi.
But my lord, I'm really concerned about this objection by the state.
Ah, no.
Yes.
Yeah, fine. You can discuss it when you are having coffee.
So is the same apply to the second witness that I was going to call, Warrant Officer
No, he
Makubu?
hasn't mentioned him in the papers here. I'm talking about what he says. He doesn't say, and so. Unless he says that, but he hasn't said that. Mr.
indeed, my lord. But
Yeah.
can you just maybe finalize our submissions?
Yeah.
Yes. I can just place on record that we did not subpoena General Shabani as my learned
Right.
friend has contended. The only witness that we requested to be subpoenaed at the request of the defense is Warrant Officer Makubo. That is the only witness.
Warrant Officer Makubu.
Yes.
And then Mr. Is that Colonel David Sibia?
Well, they indicated, my lord, that we should only subpoena
Oh, okay, fine.
that witness, yeah.
Yeah, fine.
In paragraph 2.8, we mentioned, my lord, that this case has been long running.
Yeah, right.
And the family of the deceased, the public
Yeah.
are entitled to an outcome on the guilt or innocence of the accused as soon as is practicable. And we submit, my lord, that applications of this kind delay the proceedings. And finally, as far as relevance is concerned, we mentioned paragraph 3.1 that it is not immediately clear what the relevance of those witnesses' evidence is to the question whether accused number 1 and 2 have made the disputed statement freely and voluntarily. They were not present when the accused were arrested or in any way involved in the investigation phase when accused number 1 and 2 made those statements. And, my lord, we make this submission with the greatest of respect. The aim of leading their evidence appears to want to throw a red herring and to distract from the real issues that are in dispute. We mentioned that accused number 1 will still have the opportunity to call them in the main trial if the state makes them available to the defense. We therefore submit that there is no prejudice. And finally, my lord, we make the submission that should the court be inclined to grant the application, that the state will request that Mr. Mngumezulu must indicate in detail what the relevance of the evidence is of every such witness that he intends to call.
Okay, is that it?
That is,
Yeah, I've heard you.
that's
Mr.
it.
Mngumezulu knows the law. He doesn't have to tell this court before he leads the witness whether that evidence is going to be relevant or not. I've been supplicating all in the trial, within the trial. I even made a remark that some people are going to Afghanistan or the Antarctica. When this thing, the trial within a trial is compartmentalized. It's just one issue there. Whether the state has proven beyond a reasonable doubt that these statements or confessions or admissions or pointing outs were made freely and voluntarily. But I've listened to people telling me about visiting the girlfriend in phase 2, Rustenburg. What is her name? Was he told that they're taking you away? I just kept quiet. But obviously, when this court makes a decision, it is based on what the law says. A trial within a trial is. You can read whether Mr. Numa, I see you're looking at me. State versus Muchinindi. You're aware of that case. Right. State versus Dlamini. Right? State versus Ferreira, etc., etc., etc. So Mr. Mngumezulu doesn't have to address the relevance of those witnesses. This court has granted the order that those witnesses may be called, except now, as I say, the only problem would be Le Shabani because the state says they're going to use him, if possible. Okay, so you can continue, sir. But before you do that, just synopsis of the interpretation of the legal issues which have been raised, so that the accused may understand what is happening. I know some of them do understand English. The other day I listened to accused number 2 saying, in Phokeng, I normally go to the offices there to certify documents. Am I quoting you correct, sir? Accused number 2.
Iqiniswa ngisho ukuthi inkantolo wena uke wakhuluma isingesi la enkantolo uthi wena ePhokeng unokuya uma uyocertify amanye amaphepha.
You said it in English.
Ithi inkantolo uyisho ngesingesi ngelika George.
And I can tell you, very few judges can express themselves like you. Okay, let's go on. Just tell them the
That's
synopsis.
the court business. Manje ke inkantolo ithi uthi ubaba uBhaloyi uma yesukuma lelicala leli icala ukuthi libele lithathe isikhathi la ukuthi umsolo wokuqala kakhulu ulibele anabameli umnumzane Ramsipidi oyikuthi uye wabiza umnumzane uMngomezulu ukuze azoba naye kulelicala leli kusukela nge-16 zika October 2023 la ukuthi amalungelo wenu akusukuthi alibele ayaqhamukelwa kuwo kulibelwe niyanikwa amalungelo ukuthi nina nibe nabameli futhi yonke into enilibele niyicela nilibele niyanikwa ukuthi ningayenzelwa manje ke kwamele kwazeke ukuthi labo fakazi laba njengoba nina uSibiya ecela ukuthi labo fakazi laba babizwe labo fakazi laba obuphi ubufakazi obusha obazoza nabo ngoba abameli bonke bese sebazilungiselela ukuthi bona bangadingida noma baxoxe ukuthi manje bona bacela ukuthi inkantolo ithini ngale sasigaba se trial within a trial bese sebazilungiselele lezinto ezibizwa phecelezi ama heads of argument ukuthi bazoxoxisana nenkantolo nomshushisi naye bese sekazilungisela manje into esemqoka ukuthi uma labo fakazi bazobizwa kusho ukuthi ke bonke abameli kuzofanele ukuthi bayogcwalisela kulobufakazi obusha kule ingxoxo zabo esebazenzile kwamele futhi mhlawumbe icala lizohlehliswa ukuthi bazogcwalisela ngalobufakazi lobo busha obuzabe bulethwe yilabo fakazi abasha ukuthi umnumzane Mngomezulu uthi nicela ukubabiza manje enye into esemqoka uthi umshushisi umndeni wakamufi nesizwe sonke silindile ukuthi icala leli liqhubeke ngoba kwamele kwaziwe ukuthi abasolwa banecala noma abanacala icelo ezifana nalezi zokuthi icala liyavulwa icala liyavalwa kubizwa abofakazi abasabizwa kwenza ukuthi icala lithathe isikhathi futhi icala ukuthi selinesikhathi eside libe liqhubeka njengoba umnumzane Mngomezulu naye wayekade phakama bese sekaphakama kwindaba ukuthi ivezwa naye umshushisi ukuthi kungenzeka ukuthi uGeneral Olishabane abizwe njengofakazi manje umthetho uthi uba ingabe ubushushisi buthi bunofakazi obafuna ukumbiza bese nomsolwa athi unofakazi obafuna ukuthi bambize nabo ubushushisi ibona okwamele bunikwe igunya lokuthi bubize loyo fakazi ngoba ubona ubushushisi obumele umphakathi bumele nombuso manje ke okwamanje umshushisi uthi yena uyacela ukuthi lesicelo lesi singavunywa sokuthi icala livulwe kwamele nje kuxoxwe bese kudingidwa leya ndaba ya lokhunjana yabameli njengoba bese sebazilungiselele ukuthi bona bangahle bakhulumisane nenkantolo manje umshushisi yena uyashweleza ukuthi ucela ukuthi icala liqhubeke labo fakazi laba njengoba bekade kushiwe esikhathini esidlulile ukuthi abameli bebavumelene ukuthi labo fakazi bangabizwa icala uma seliqhubeka phakathi kwecala nina uma nizobiza abofakazi benu kodwa manje njengoba ukuthi bathi nifuna ukuthi babizwe manje uthi umshushisi lokho ubambezela icala ingamafuphi izinto azishilo umshushisi.
Right, Mr. Mngomezulu, let's continue then.
My Lord, may I have a directive as to...
Now, I call your witnesses. The state, I told the state that I'm found to Sufiki have made an order already. That
May I call General
the court
Chairman?
should be opened, I mean the case of accused number 1 should be opened, and that the witnesses which you intended calling should be called except General Leshabane, because the state says they intend or they may still intend using him in the
Thank you,
meantime.
ma'am.
Okay,
I understand now.
all right. Sir.
Thank you. Court, please. May I call Warrant Officer Mako?
Manje ke kubizwa warrant officer uMakhubo.
Yes, sir.
While still waiting for Warrant Officer Makwe, I just want to draw my learned friend's attention to Section 210 of the Criminal Procedure Act,
Yeah.
which
okay.
reads as follows: no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point or fact at issue in criminal proceedings.
Mr. Gomezul is aware of that section.
I'm aware of this section.
Yes. Yes, swear the witness in, sir.
Amagama wonke nesibongo unayo into evimbayo ukuthi ungafuna ukuthi uqiniso manje uma uvuma uyafuna ukuthi ufakazi uzobethula la enkantolo kuzoba iqiniso lodwa iqiniso liphelele uma kunjalo phakamisa isandla sakho sokuthi uthi inkosi ngisize ukukhuluma iqiniso witnesses sonen
Yes.
ukukhuluma ukhulumele phezulu.
Thank you, Madam. Sir, is it correct that you are the member of the South African Police Services?
Iqiniso ukuthi uyiphoyisa mnumzane?
Yebo kunjalo.
Yes, that is correct. Ngicela ukhulumele phezulu ba.
What is your current rank?
I-rank yakho yiphi?
Ngiyi-warrant officer.
Warrant officer.
Can you please place your... So currently, where are you stationed?
Usebenzela phi
Which
okwamanje?
unit are you?
Kuyiphi unit?
DPCI.
DPCI. Ngicela ukhulumele phezulu baba abafowethu nabo bakwazi ukuzwa bonke bobahlali.
Oh, okay.
Can you, for record purposes, can you explain what is the DPC?
Ngicela uchaze ukuthi yini i-DPCI?
Directorate for Priority Crime Investigation.
It's Directorate for Priority Crime Investigation.
Is that commonly known as Hawks?
Ile eyaziwa njengama-Hawks.
Yebo.
That is correct.
Where are you based?
Usebenzela phi?
Number 165 Mayor Street, Germiston.
165 Mayor Street in Germiston.
Can you please place your career history for record purpose?
Sicela usitsheleke ukuthi wena umsebenzini wakho waqala nini kufikela namhlanje.
Angiqala ngo-1992.
I started in 1992
Sebenza ku-uniform.
working as a uniform officer.
Yes.
Beka.
Ngabuya ngaya
Sir,
ku-Medroba.
can you please speak up? I've got bad hearing capacity.
Inkantolo
Khuluma
nayo-
njengami, ngaqala 1992. Everybody must hear you. Bangaphumi lapha abantu bathi hayi asimzwanga. Because our people want to know what is happening with the case. Please.
Inkantolo nayo icela lesi sicelo engilibele ngisifaka nami ukuthi icela ukhulumele phezulu wonke umuntu umphakathi ufuna ukwazi ukuthi kwenzakalani kule cala. Icela ukhulumele phezulu ba.
Ngiyabona. Izingozi enkantolo.
I hear you my lord.
In 1992, say, where were you working?
Ngo-1992 wakade usebenza laphi?
Angisebenza eKatlehong police station.
Mkatlehong police station.
Then, after 92, what?
Ngemva kwa-1992 kwayenzakalani?
Ngabe sengiya ku-Murder and Robbery.
I then was transferred to the murder and robbery unit.
Which year was that?
Ngamuphi unyaka?
Noma ngasakhumbuli kahle ku-1998.
Even though I do not recall very well, however, I think it was in 1998.
Then, proceed.
Ungaqhubeka?
Then i-Murder and Robbery bayiphelisa ngaya ku-Serious and Violence Crime Unit.
And then they stopped the murder and robbery unit, and I went to serious
And Violence Crime Unit.
and violent crime unit.
Yes.
Qhubeka ba.
Ukusuka lapho
So, which year was that? Sorry.
Ngamuphi unyaka?
enyaka ngisawukhumbula.
I cannot remember which year.
All right, proceed there.
Ungaqhubeka?
Ngisuka lapho ngaya ku-organized crime eGermiston.
From there, I moved to organized crime in Germiston.
Yes. I can't
Ungaqhubeka?
recall which year was that as well.
Umuphi unyaka nawo awusakhumbuli?
Angisakhumbula.
I cannot recall the year.
Yes, proceed.
Ungaqhubeka?
Ngisuka lapho kwaba khona ithimba okuthiwa i-SOX, Serious Organized Crime Section.
From there, there was a team which was referred to as SOX, Serious Organized Crime Section.
Yes.
Ungaqhubeka?
Then, 2010,
Then in 2010,
ngaba ku-DPCI.
That's when I was moved to DPCI to date.
All right. Do you still remember which year was the DPCI launched?
Usakhumbula ukuthi i-DPCI le yaqalwa ngamuphi unyaka?
Futhi ukulonjwa yalonjwa ngo-2009 mara ukusebenza ukuthi kusetshenzwe kwaqala ngo-2010.
It was launched in 2009, however, it started functioning in 2010.
So, in relation to the matter that you were called to testify today about the death of Senzo Meyiwa, can you tell the court how are you related to this case?
Manje ukuya ngaleli cala leli obizwe ukuthi uzophana ngobufakazi ngalo namhlanje leli cala lokubulawa kuka Senzo Meyiwa, ungatshela inkantolo ukuthi wena ubandakanyiseka kanjani kuleli cala? Macala ngaphambili.
Obstructive, but we object against this evidence. We submit that it is not relevant. At this stage of the proceedings, my lord, the question is whether the statements that were made by the accused were made so freely, voluntarily, whilst they were in their sound and sober senses, and without any undue influence. We submit that this line of examination has got nothing to do with the issues that are at hand.
It's what?
That this line of examination by my learned friend has got nothing to do with the issues that are at hand, and therefore the evidence is irrelevant.
Okay, yes, Mr.
My Lord,
Zulu.
for the state to prove the requirements of Section 217, the state called Kenan Swanepoel, and it is my submission that it never took the state. I'm not arguing, but it was not relevant.
Otherwise, it's over like the whole day.
Yes.
The objection is simple. The line or the trend of your examination
Yes.
has got nothing to do with a trial within a trial. That's the objection. Now that Swanepoel, what have you, please?
But to prove all the elements, say, in relation to this matter, do you have anything to do with an event that occurred in 2019 that relates to accused number 1?
Kule cala ikhona into ekuthi uye wathatha inxaxheba kuyo mhlawumbe ngo-2019 ukuya ngomsola wokuqala.
Mhlambe mawungangitshela umsolo wokuqala ubani igama lakhe mhlambe.
Perhaps if I could be given the name of accused number 1,
Mozi Temba Sibia.
Muzithemba Sibia.
Ngo-2019 ngabizwa uGeneral Shabane.
In 2019, I was being called by General Shabane.
Yes.
Qhubeka.
How were you called?
Ukubize kanjani?
And what was the reason for you?
Ekubiza isizathu kwakuyini?
Wangifonela
He contacted me telephonically
wathi une-information mayelana necase kaSenzo Meyiwa.
and he said there was information with regards to the matter of Senzo Meyiwa.
Yes.
Ungaqhubeka?
Ngabe sengiyambuza mina ukuthi ngoba la wayafonela mina ngoba so-4 kule case.
And I asked him,
Abantu so-4 wayafonela mina.
and I asked him, why am I the only one that is being contacted, as we are a team of 4 members?
Is my learned friend now going to lead evidence on the hearsay of General Shabane? This we submit, my lord, that it's irregular. The evidence of what General Shabane told this witness is not admissible.
Yeah, Mr. Gomezu.
My Lord, that's the reason why I intended to call General Shabane to confirm.
Yeah, but we've traversed that. If Shabane is going to testify for the state, you can't call him. Able to, please.
Yes, that's what I'm saying, my Lord.
Yeah, you can't call him. You know that. That's the law. You can't. It can only be called by the state. And I told you the consequences of him refusing if he's called by the state. They can use section 205 or 204, etc., etc.
My Lord, the provisions of Section 3
Yeah.
are applicable of the Law of Evidence Amendment Act. In that the evidence that is given by this witness, it has also been given by accused number 1.
Who gave that evidence?
Yes.
Who gave that evidence?
Accused number 1.
He gave that evidence
That's correct.
himself. That's what section 3 of Act 48 of 55 pertains to hearsay evidence which is given by witnesses. Is that not so, Mr.?
This witness is relating the evidence of hearsay.
No, but we're talking about accused number 1 now.
Yes.
Yeah.
I'm saying the evidence that is before this court in a trial within a trial was led by accused number 1, insofar as General Shaban is concerned.
What did he say? I thought he never spoke about General Shabani
He spoke about
in the trial within the trial. He spoke about him in the merits. He was spoken of in the merits. Mr. Ngumalo, do you recall that evidence?
No,
Hello?
he testified about the interview that accused number 1 had
Was it in a trial within a trial?
in the trial within the trial.
Ms. Mshololo?
Yes, my Lord, it was in a trial within a trial when accused number 1 was testified.
Right, Mr. Miyeki?
Indeed, my lord, it was.
Mr. Right, Mr. Baloi, they say he did testify in a trial within a trial about Le Shabani.
It doesn't make the evidence of this witness acceptable. It still remains
Because
hearsay.
he had the evidence from, who else? He hears the evidence not from accused number 1. He hears the evidence from accused, from Le Shabani, you see. Angisho se. You say you were phoned by Le Shabani. You were not phoned by accused number 1.
That is correct, my Lord. I was contacted by General Shabani.
Right, that's what he's saying. Yes, Mr. Mgomezulu.
Sorry, I didn't hear that, my Lord. They were whispering to me, my colleague.
This witness says he was telephoned by General Shabani and told that there is information concerning the murder of Menzi, Senzo
Meyiwa.
And he says he was surprised because there are 4 in that case. Why should Akondena, why should he be
That's correct.
favored with such information? That's what.
So, can you proceed, sir? You said you asked as to why do you say you are also a investigating team in this case?
Manje uthe uye wabuza ukuthi kungani ushayelwa ucingo wedwa. Kungani wena uthi ungomunye wabaphenyi kuleli cala?
Njengoba sabekwa uNational Commission noMinister
Because we were appointed by the National Commissioner and the Minister to investigate this matter.
But did you attend to the call of General Shaban?
Kodwa logo obekade uGeneral Shabani akhuluma ngakho uye wakwenza.
yebo ngingakwenza.
Yes, I did attend to his call.
Can you
man.
please tell the court what happened?
Awutshele inkantolo ukuthi kwenzakeleni.
Chlorocope bengayazi kahle.
I did not know Chlorkop properly.
So mangilong driver belong director
As I was driving, he was directing me
because mhlawumbe isikhathi lapho kungabo 8 ebusuku.
because it was at around 8 p.m.
Bangidirector ngaze ngafika eChlorocope.
He directed me until I arrived in Chlorkop.
Where exactly in Chlorocope you were directed?
Ukudirecte ukuthi ufike kuphi eChlorkop.
eChlorocope kune-office lamaphoyisa lapho.
There is a police officer's office in Chlorkop.
Yes, upon your arrival, what happened?
Mawufika kwayenzakalani?
bangifika bangifaka kwelinye office ngiyacabanga ukuthi office lakhe the way lalibukeka ngakhona
Upon my arrival, he had put me in a certain office. I think it was his office because of the way it looked.
Yes.
Yebo.
so ukufika kwami lapha ngathola ngoba sasihamba naye uGeneral Shabane ngathola ebengimazi uGeneral Sibiya but ngaleso sikhathi leso wayengasasebenzi emaphoyiseni.
Upon my arrival, as I was in the company of General Leshabane, I had found a person that I knew who was General Sibia. However, he was no longer in the employment of the police.
And then ngathola omunye wayegqoka uniform kodwa ngafakanga ama-epaulets ama-rank.
And I got another police officer who was in uniform but did not put his ranks, the epaulets.
Yes.
Ngaqhubeka.
So General Shabane waqala wathi kimi
So, in relation to in the office, is there anything that was significant that you were called for?
E-ofisini ikhona into ebeyibalulekile ebowubizelwe yona.
njengoba bengisho ngithi efonini wathi kimi ungibiza ngoba une-information yecase kaSenzo Meyiwa.
Like I said, that on the telephone, he had informed me that he is calling me with regards to information that he has with regards to the case of Senzo Meyiwa.
Yes.
Ngaqhubeka.
Mase silapha e-ofisini ke washo ukuthi lona usho ukuthi angazisi ukuthi abobani laba la e-ofisini.
When we got to the office, he introduced me to the people that were in the office.
Abese kasho ukuthi lona uyamazi uGeneral Shedrack Sibiya ngiyamazi bani.
And he informed me that I knew General Shedrack Sibia, whom indeed I knew at that time.
Wabese athi lona uConstable Zungu ilonga ngithi wayefake i-uniform.
Then he introduced Constable Zungu, whom I had said that was a police officer that was dressed in uniform.
So the information, was it related to you regarding the death of Senzo Meyiwa?
Manje uye wanikwa ke lolo lwazi le information le bekakhuluma ngayo ngokufa kuka Senzo Meyiwa.
Yebo kunjalo.
Yes, that is correct.
What was said to you?
Kuthiweni kuwe?
Once again,
Hello?
really we object to this kind of evidence. We've already raised an objection that it's irrelevant, it's CSA evidence. We're going to leave it at that, my lord. We're not going to raise any further objection.
May I withdraw that question, my lord? Sir, was there anything relating to accused number 1 that was mentioned in that office?
Ikhona into ebekade imayelana nomsolo wokuqala eyakhulunywa ngalelo langa kuyo lelo office.
Bakhuluma ukuthi bambopha nge-19 zikaMarch.
They had said they arrested him on the 19th of March,
Bambophela yona icase kaSenzo.
arresting him for the case of Senzo.
Sorry, 19 March, which year?
19 March kumuphi unyaka?
2019.
2019.
Yes. In that office, what was after you were informed about his arrest, accused number 1?
Sorry. Mr. Mgomezulu, when allegedly did Mr. Senzo Meyiwa die?
Sorry, ma'am.
Allegedly, when is it said that Mr. Senzo Meyiwa died?
26 October 2014.
2014.
Yes.
Okay, fine.
Proceed.
Ungaqhubeka?
ukuthi kusaqhubeka
I said,
You
when-
were still asking me a question.
yes. In relation to accused number 1, I want you to tell the court your involvement about what you were told about accused number 1.
Manje ufuna ukuthi utshele inkantolo ukuthi wena uye wayenzani ngalento ebukade utshelwe ngomsolwa wokuqala.
futhi mhlambe ngichaze or ukuthi mawuthi akuthamzisisi kahle ngangenzani
I
or
do not-
ngichaze mhlambe
I do not understand the question properly. Should I explain what I did, or how am I supposed to respond?
All right. There's a problem that problem of the state. If you say this is what was said by General Shabane, it amounts to hearsay. But now what accused number 1 told the court that he was arrested on the 19th of March 2019. What actually happened, because you cannot say what General Shabane has said. According to your own, after you have been related with the information about the death of Senzo, you as warrant officer, you as the investigating officer in this matter, what did you do?
Uthi ummeli kuba nenkinga uma uthi ulishabani uye wathi ulishabani uye wathi ulishabani uye wangitshela ukuthi lokho kuba nenkinga ingokho umshushise libele ephakama. Ufuna ukwazi ukuthi wena njengephoyisa ebelikade liphenya wenzeni ngokwakho.
futhi information bebanayo beyishayisana nalo lwazi mina engilaziyo mayelana nale case
The information that they had was contradictory to the information that I had relating to this case.
What do you mean by that?
Usho ukuthini uma usho kanjalo?
ukuthi ngeke ngisasho ukuthi bathi ngo-number 1 kwenzakalani baze bathinta ngo-number 5 u-number 5 ngiyamazi-ke
I will not state what they said with regards to number 1. They also implicated number 5, whom I know.
Okay. Accused number 1 has told the court that he was arrested by the police, he was assaulted, he was taken to Chlorocop for interrogation. And accused number 1 told the court that there was Zongo. He had the names because he didn't know who those people were. He had the names of Zongo, Makubo, Sibia, and Shabane.
Umsola wokuqala yena uthi yebo uboshiwe ngo2019 la ukuthi uye washawa futhi wayisiwa eChlorokop wezwa ngoba wayekade engabazi labo bantu wezwa amagama uZungu, uSibia, Makhubo noLshabane.
njengoba sengichazile ukuthi mina bengikhona eChlorokop kukhona mina kukhona uZungu kukhona yena uGeneral Shabane noSibia
As I have testified that
kulelo office lelo ngangikhona kulo
I was present in that particular office in Chlorokop, Zungu was present, Sibia was present, as well as Leshabani in that particular office that I was in.
All right, sir. Let's say after that meeting, being the investigating officer of the case, was accused number 1 charged formally from the information that were given
Manje ngale ngemva kwalowo mhlangano onibe nawo kule yankantolo kuleli office. Umsolwa wokuqala uye wathweswa amacala na ngemva kokuthi uthole lelo lwazi leli belikade
Was
nihlanganele
he
lo.
charged with the death of Senzo Meyiwa?
Uye wathweswa icala lika Senzo Meyiwa lokubulawa kuka Senzo Meyiwa.
Ngokwazi kwami azange wagcina ngokuboshwa nje kodwa azange ekhotho.
According to my information or knowledge, the last that happened was for him to be arrested, but he never appeared in court.
All right. So when did you learn that accused number 1 was further arrested on the same allegations?
Manje uzwe nini futhi ukuthi umsolwa wokuqala uboshiwe ngazo lezo insolo lezo?
Mina ngazo nje kuthiwa kunabantu ababoshiwe abawu-5 ekhasini kaSenzo.
I only heard that there were 5 people that were arrested with regards to the case of Senzo Meyiwa.
I did not mean that we must give evidence against the state, because we are also working for the state. But if you have any knowledge in relation to how a confession is taken, can you assist this court?
Sorry. I like to understand concepts. You are putting it to this witness that you don't intend him to give evidence against the state because he is working for the state. Am I understanding you correctly?
That's correct. I'm
What is he
requesting
doing
this
now?
court-
I thought you said he's still a policeman.
Yes,
He's not giving evidence against the state.
he is, but.
Okay, fine. As long
that's
as you're
correct.
clear there.
Can you please assist the court in relation to the procedure of taking a confession? If a suspect intends to make a confession, what procedure must be followed?
Please, the court, please, my lord. How can
Yeah, we know that he's not a justice of the
a
peace.
junior
Don't
officer-
complain about that.
Yes, as the court, please.
We all know the law. He said he's a warrant officer.
That's correct.
It's not the justice of the peace.
My lord, I never said he took a confession.
You said the
He has
procedure.
referred matters
Okay, fine.
where the suspect,
Fine.
if, say, let me just clarify this because I can see there's a bit of misunderstanding. Since the years of your employment in the SAPS, have you came across a suspect who wanted to make a confession? And what procedure did you follow?
Kuso sonke lesikhathi lesi osisebenze njengephoyisa kuke kwaba nesikhathi na la ukuthi umsolwa uke wafuna ukugunyuluka efuna ukusho iqiniso lezinto ezenzakele mhlawumbe wena uma ingabe uye waba nalo lolo lwazi wena uye wathatha ziphi inyathelo
Ekuphenyeni nje baningi abagonyoluka ekuphenyeni kwami.
upon my investigations there are a lot of suspects that confessed in my investigations
Yes.
ungaqhubeka
What is the procedure that you usually follow?
eziphi inyathelo enizithathayo uma umuntu sekazogonyuluka
Okay, ngizoqala kanje.
I will start in this manner.
Ususpect uyaboshwa.
The suspects get arrested,
Ngaleso sikhathi une-evidence.
and at that time you would be having evidence.
Ususpect ifanele ecourt before 48 hours expired.
And the suspect should appear in court before the expiry of 48 hours.
So ufanele wena njengomuntu ophethe icase umcharge before ecourt.
And as an officer, you need to charge that person before they appear before the magistrate.
Ukumcharge-ke umthatha imino yakhe.
And charging a person, you need to take their fingerprints.
nokuthi umthathe i-warning statement.
and also take a warning statement.
Yes.
Ungaqhubeka?
Inkinga ke ifika la ku-warning statement. Khona la kuyipart i-warning statement ebhaliwe ukuthi statement by the suspect.
Manje, now the problem comes where there is on a warning statement where it says warning statement by the suspect.
Yes.
Ungaqhubeka?
Where's the problem?
Inkinga iba kuphi?
Yilapho kange soyamchazisela.
That is where
Somtshelile amalungelo wakhe.
That is where
Kuyi-warning.
you are now explaining to the suspect after you have informed him of their rights according to the warning.
Yes.
Ungaqhubeka?
I understand because uyamtshela ukuthi i-evidence onayo yiphi nayiphi eyenza ukuthi umcharge la.
And that suspect would understand, and you then inform the suspect of what evidence do you have that makes you to charge that suspect.
Yes.
And then basuyamtshela ukuthi kukhona ofuna ukusho na ngoba le form liyakuleader ukuthi no kukhona lokumela kusho la kule form abese assigna la ngaphansi.
And you then inform the suspect that is there anything that you want to say, and then at the end the suspect would sign after the
Yes.
suspect has informed you.
Uyahluka ngesikhathi omunye makathi uzokunikeza statement athi mina ngizokhuluma ecourt.
It differs. Some of the suspects, they would then say they will speak in court when you're asking them for a statement.
Yes.
Okunye ke ususpect uyagonyuluka makagonyuluka mina as a warrant officer yastopa.
And at some instances, the suspect would then confess, and upon them confessing as a warrant officer, I would then stop.
Yes.
Ngiyababa.
Kuluka ngitshela kona okuhambelana nale case engiyiphethe agonyuluka ngako. Bese ngiyambuza ngimtshela amalungelo wakhe ngimtshela ukuthi akafostekile ukuthi no angayikhuluma lento la kimi.
Upon what the suspect is informing me, I would stop the suspect and inform them that they are not forced to tell me what they are about to tell me.
Yes.
Bese ngiyambuza ukuthi uma ngathola omunye umuntu ongazi lutho ngale case esikhuluma ngayo angamtshela yini lokho angitshela kona yena.
Then I would ask the suspect if I am to get an independent person that doesn't know anything about this particular case that we are referring to, will the suspect be able to inform that independent person what they wanted to inform me?
Uyaphendula komunye ukuthi akunankinga.
Then some suspects would agree that they do not have any problem.
Yes.
Mangathi akanankinga bese ngiyafona ngifonela mhlawumbe ucommander wami branch commander.
If the suspects say they do not have a problem, then I would contact my commander, which is the branch commander.
Then ngiyamtshela branch commander ukuthi ngiphenya iqala la ngine suspect lana ngiyayicharge bengibhali warning uthi ufuna ukwenza ufuna ukugonyuluka.
And then I would inform the commander that I was charging the suspect, and whilst we were busy with the warning, the suspect wants to now make a confession.
Yes.
Kodwa ebengicela ukuthi ngichaze
However, this is what I would like to explain.
kule warning le njengoba sashilo ukuthi akanankinga yokuthi angatshela omunye umuntu
On that warning statement,
ngale case le engimchargela yona.
on that warning statement, as the suspect had already confirmed that they would not have any problem informing an independent person with regards to the particular case,
Ngiyabhala la khona la ngibhale ngithi no ususpect ufuna ukugonyuluka.
I would also write that the suspect wishes to make a confession.
bese ngiyamsayinisa la ngaphansi.
then make the suspect to sign underneath.
And then kukhona ispace futhi la kusayina mina khona.
There is-
as an investigating officer.
There is also a space where myself as an investigating officer will sign.
Bese futhi kunye ngimbeka isithupha sakhe la asayine khona eduze kwesignature yakhe.
Then I would also take the thumbprint of that suspect and place it next to their signature.
Bese ngitshela ubranch commander ukuthi angi-arrangele. Mina ngingeni phela njengomuntu ophenya icala. Angi-arrangele kune-suspect efuna ukugonyuluka.
Then I would inform the branch commander to arrange for me, as I am not part of it. I would ask the branch commander to arrange someone because the suspect wants to confess.
So the place where the suspect is kept, does it matter as to the place where the suspect is kept?
Manje la umsolwa ayigcinwe khona leyo ndawo iyaze isetshenziswe noma yanakwa ukuthi ugcinwe kuphi.
No. Angithi makasebaqedile uzobuya kimi ubranch commander athi umuntu ngimtholile bese ngiyamthatha ngimyisa e-police station Maseleni.
No, the branch commander would come back to me and inform me that they have gotten that independent person, and then I would then detain the suspect into the cells.
Yes, proceed.
Bega.
Bese ngiyamtshela ubranch commander ukuthi igama le-suspect ubani.
And I would then inform the branch commander on who the name of the suspect is.
Angimtshela ama-details we-case. Ngimnikeze igama le-suspect, ngimnikeze i-SAP 14, ngimnikeze nokuthi udetainwe kuphi kuphela.
I do not disclose the details of the matter. I would inform the branch commander of the SAP 14 and where the suspect is detained at.
So is that all that you want to share with the court?
Yiko kodwa lokho ofuna ukutshela inkantolo?
Branch commander uzenza konke yena, mina ngene lapho.
The branch commander would do everything and I would not be involved.
Nalaba mhlambe thola ukuthi mhlambe bengihamba nabo siyokwenza arrest nabo bangeni lapho abasondeli nje lapho.
And other arresting officers that maybe I was in company of when we arrested the suspect, they are also not part of that.
In relation to this matter, there's evidence before this court that by Brigadier Gininda that he interviewed accused number 1 at Fosloras police station where accused number 1 made some admissions or he spoke as if he's making a confession.
Manje la enkantolo kuleli cala esibhekane nalo kunobufakazi obulethwe uBrigadier Gininda ukuthi ubekade ekhuluma nomsolwa wokuqala emhloma ibibuzo la ukuthi umsolwa wokuqala yena uye wakhuluma ebonakala ingathi kunezinto afuna ukuzivuma noma egonyuluka.
In terms of, in comparing your evidence, I understand Brigadier Gininda is a commissioned officer. He can take a confession.
Uma bandakanisa nobufakazi bakho uyezwa yena ukuthi uBrigadier Gininda ungumuntu oyikuthi angakwazi ukuthi athathe istatement somuntu uma egonyuluka.
Yebo ngakwazi ukusithatha istatement somuntu as a commission officer.
Yes,
Ukuthi agonyuluke mara makaphethe icase hlukile ke lokho.
yes, he would be able to take a statement of a person when they confess. However, if he is the lead investigating officer, it would then be different.
Yes. Is it the same case as you have mentioned that if a suspect wants to make a confession, you contact your branch commander.
Uyafana njengoba uqada ukuchaza manje ukuthi uma umuntu sekafuna ukugonyuluka kanjalo kwamele ushayele ucingo ku branch commander yakho.
The witness is being asked to express an opinion, which we submit, my lord, is irrelevant. But we're going to leave it at that.
May I withdraw the question? May I withdraw? May we adjourn for?
No, let's go on, please. Time has been wasted already.
It's 20 to 12. It's fine. Okay. In relation to the evidence that is in this court, according to your evidence, you said even those people that were present during the arrest of the suspect are not even supposed to be closer to the suspect when he's making a confession.
Ukuya ngobufakazi bakho. Nalabantu laba bokade uhamba nabo ngalesikhathi bekuboshwa umsolwa akwamelanga ukuthi basondele ngalesikhathi umsolwa eyogonyuluka kanjani.
Once again, this is opinion evidence. We've made the submission that it's irrelevant.
I'm referring to him. That's the evidence given by him. That's the role he's playing when he's interrogating a suspect. That is his evidence. That even the arresting officers that were present, in this case, being the investigating officer, am I correct to say, are you the investigating officer of 636 of 10/2014?
Umshushisi ummeli uthi ufuna ukwazi ukuthi wena iqiniso nawo ukuthi wena iphoyisa eliphenyayo kuleli cala u636 of 2014.
Bese ngishilo ngabekwa National Commissioner no Minister wamaphoyisa kule case.
As I have
636 of 10/2014.
As I have previously stated that I was appointed by the Minister of Police and the Commissioner to investigate in the matter 636 of 10 of 2014.
So you mentioned 4 people that were appointed by the minister. Do you know if Sergeant Mukhola and Sergeant Mukhani were also part of those people who were
Ukhulume
appointed
ngabantu
by the
abane.
National Commission?
Ukhulume ngabantu abane ukuthi bona bebakade beyingxenye yalolu phenyo. Uyazi ukuthi uSergeant Mukhola no Sergeant Mukhani bekade kungabanye abantu abekuthi bebakade bekwe uCommissioner nomphathi wamaphoyisa.
What is the relevance of the question that my learned friend is asking?
There's evidence before this court that they were part of the investigating team under the lead of Brigadier Gininda. I want the witness to agree if he has the knowledge of the of Mohane and Mukhola during the investigations in this case.
Uthumela uyazi ukuthi uMukhani noMukhola nabo bekade kuyingxenye yalabantu bekade bebekwe uCommissioner nomphathi wamaphoyisa. No, I do not know.
Okay. So, when accused number 1 was arrested, including accused number 2, 3, 4, and 5, were you contacted by either or by one of the investigating officers that were appointed under 636 10/2014?
Uma umsolo wokuqala eboshwa nabo bonke laba owemsolo wesibini wesithathu wesine nowesihlanu uye wathintwa na washayelwa ucingo mhlawumbe womunye wabaphenyi balecala u636 10/2014?
Azange akekho ngifone.
No, there is no one that contacted me.
There's evidence that has been led by the state to the effect that this matter, 636-10, 2014 is one of the matters that falls under the cold case unit.
Kunobufakazi obulethiwe la enkantolo ukuthi lecala lelu 636 elinye lamacala ekuthi awela ngaphansi kwale unit ye cold case.
What is a cold case unit?
Yini I cold case unit?
The cold case unit. Abantu abaphenya ngamacala lawa asafayiliwe kuma archives afayiliwe.
Cold case unit, it's a team that is investigating matters that have been filed and archived.
So is this matter 636, was it one of the matters that were filed?
I 636 kwakade kungenye yamacala abekade efayiliwe.
How would the witness know that? And what is the relevance of all this?
The witness is the investigating officer, unless the state will rebut the fact that he has never been appointed.
Who was the chief? Sorry, maybe let's get this. Who was, according to your instructions, who was the lead investigating officer? Because maybe even Rachamakwatleng was an investigating officer of a lower rank. Maybe my job was just to polish the shoes of Brigadier Ginenda.
My lord, according to my instruction,
Yes,
as
yes.
the court so request to, according to my instruction is that there's no one who was appointed to lead the investigation. They were all,
Okay, fine, no problem, I hear
Yes.
you. So when Ginenda comes here and says he's a lead investigator, he was not being frank with the court.
that's
Okay, fine.
what I'll argue
Okay, fine.
at a later stage.
All right.
So, sir, do you confirm that instruction that under 636, no one has been appointed by the National Commissioner to lead the investigation?
Uyavuma nawo ukuthi kule cala u636 akekho umuntu obekade yena embekiwe ucommissioner noma umphathi ukuthi kube uyena oyikuthi omkhulu kule.
Ngithi kwathiwa loba no4 nizophenya lelicala. Akuzange kuthiwe wena uzohamba phambili or ulide laba. Akuzange kuthiwe kanjalo.
When we were appointed, we were informed that we will all investigate this matter. There was no one.
Irrespective of rank.
Akuzange kubhekwe nokuthi irank kabani ithini nivele kwathiwe nje nonke nizophenya.
Into eyenza lokho ukuthi uminister asho kanjalo. Bukhona abantu abalinganayo ngamarank. So azange akwazi ukuthi abheke umuntu ukuthi athi wena uzolida le investigation.
My lord, what made the minister to say that is because there were people that were equal in ranks, and that is why the minister did not choose anyone to lead the investigation.
So everybody was leader. You
Wonke
are
umuntu-
equal. Nobody makes a decision. All of you are equal.
wonke umuntu ke bekade niphenya nje nonke nilingana, akekho obekade ethatha isinqumo.
No, ngichaza ukuthi ngizosho ngamagama uKenneth Gininda noKenneth Ramkhal bekurank A1.
My lord, Colonel Gininda and Colonel Ramukhali were in the same rank of A.
Yes.
So kukhona noCaptain Buthelezi
And there was also Captain Buthelezi,
also kuba yimi warrant officer Makhubo.
and there was myself, Warrant Officer Makubo.
So, when when you appointed, if I want to get it correctly, you said what evidence do you have that were appointed to investigate this case 636?
Obuphi ubufakazi obeninabo noma yini
That you
into
received.
engabonakanisa njengobufakazi ukuthi ubekade nawe ungomunye umuntu obekade ebekiwe?
As a court, please.
Mr. Balwe, I know he's now cross-examining his own witness. Please, let's go on with this case.
I'm not cross-examining, I'm putting, say, according to your involvement in this matter, you were not, or at any given stage prior to the arrest of these 5 accused, you had a meeting with the rest of the investigating officer appointed.
Sikhona isikhathi ukuthi niye nahlangana njengabaphenyi balecala ngaphambi kokuthi abasolwa baboshwe.
Asihlangane kaningi.
We indeed had meetings.
But in relation to the confessions that were allegedly made by accused number 1 and number 2,
Ukuya ngokugonyuluka lokho kwenziwe umsolwa wokuqala nowesibini.
Hayi cha, asihlangane.
No, we did not meet with regards to the confessions.
so are you saying you were not involved in the taking of the confessions of accused number 1 and 2? And are you also saying that it was not by agreement between the investigating officers?
Manje uthi wena awuzange ube ingxenye yaloko kugonyuluka okwenziwe umsolwa wokuqala nowesibini futhi nina njengabaphenyi nanikade ningavumelananga ngaleyo nto.
Okay, you can just mention accused number 1.
Uthi ungakhuluma njengomsolwa wokuqala. Umsolwa wesibini ungakhulumi ngaye.
Kulama meeting besiluke siwahamba.
On the meetings that we held,
Kwaba nembono ehlukene. Ingakho kwaba khona ukuhluka kwaba khona
there were different opinions.
Yes.
so kwaba ngamaqembu ayi-2.
And that is when we divided into 2 teams.
Lokho kwazenzakalela ngoba kwaba nemibono ehlukene.
It naturally happened because we had different opinions.
Ingakho noma kuboshwa abamangalelwa laba azange saziswe mina no Colonel Tellis.
And that is why, even when the suspects were arrested, we were not informed, myself and Colonel Buthelezi.
So let's get back. You said, insofar as your knowledge about the cold case, this case was not filed. It was still under investigation. Is that your evidence?
Uthe wena ukuya ngolwazi lwakho lelicala lona lalikade lingakafayilwa ukuya ngolwazi lwakho.
Mina ngafayilwa lelicala leli into engenza ukuthi ngisho ukuthi belingakafayilwa. Uminister yathi makasibeka wathi bekunama member of 40 aphenya leqala.
Yes, this matter was not filed yet, and what makes me to say that is because the minister, when he appointed us, he said there were 40 members that were investigating this matter,
So bakoshile ufaka thina.
and,
So 4.
and he had dismissed all of them, and he was now appointing the 4 of us.
So, in connection with the investigations, and you even said there were 2 camps because of different opinions.
Manje ngalolu phenyo njengoba uye wathi nigcine sekuthi seniyahlukana kuba amaqembu amabini ngoba nanikade ninemibono ehlukile.
So was there any consultation with the state prosecutor or the director of public prosecutions in relation to your independent opinions?
Kunesikhathi la ukuthi mhlawumbe niye nakhulumisana nomshushisi noma abaphathi babashushisi ukuya ngale mibono yenu ehlukile.
Yebo kunjalo.
Yes, that is correct.
Please tell the court.
Tshela inkantolo.
mhlaka idate angisayikhumbuli mara oku 2020.
Even though I would not recall the date, but it was
2019.
but it was in the year 2019.
So sase office in laga advocate Baloyi.
We were in Advocate Baloyi's office.
Sizokhuluma ngayo indaba yale case.
To speak about this particular case. Qhubeka.
Ngabeka umbono wami ku advocate Baloyi.
And I have given Advocate Baloyi my opinion.
Yes.
Qhubeka.
Ngalo lonke uphenyo lalo mbono wami ohlukile
About the investigation of my different opinion.
Yes.
Qhubeka ba.
so sashi docket kuye.
And we left the docket in Mr. Baloyi's office.
If you say we, with who were you?
Uma uthi sa shia docket. Bonobani.
Okuye mno Colonel Tellez.
It was myself and Colonel Buthelezi.
Yes.
Yebo.
Uma kusenjalo kwafika uColonel Geninda kwafika ne docket leli linye
And
abayithula ama docket.
And after that, whilst we were still there, then Colonel Gininda came with another docket. Then there were two dockets.
To mention which docket is that? Is it 636 and?
The ama docket ungasho bewe 636 naipi.
First Lawyer's case 375
First Laura's case 375
stroke 1 stroke 2019.
stroke 1 stroke 2019.
So you left these two dockets with Advocate Baloyi, or is the only one docket that you left with Advocate Baloyi?
Lama dokoto mabini nawa shia no Advocate Baloyi noma na shia a lot.
Asala wethu.
We left both of them.
Then you said Brigadier Gininda arrived. What do you mean by that?
Uthe Brigadier Gininda wafika usho ukuthini ngalokho.
Wayefika phethe docket 636 First Lawyer's case 636
He came in position of a docket First Laura's case 636
stroke 10 stroke 2014.
stroke 10 stroke 2014.
Yes.
Yebo.
What's the relevance of that? What did you do with the docket?
Ibaluleke kanjani lento oyishoyo wenzeni ngaleyo docket?
Ukuthi phela njengomthuthisi athathe decision lento esiyenzile le investigation esiyenzile.
So that the prosecution would take a decision on the investigation that we had made.
My apologies for interruption. I just got a note that accused number 3 needs some comfort.
What's the time, Mr. Baloyi?
It's 12 o'clock exactly, my lord.
Yeah, we're adjourned for 3 minutes. 3 minutes. Yes, sir.
Thank you, my lord. So, Mr. Makobo, I think that will be my final question.
Umbuzo wakhe wokugcina nawo.
Was there any letter that was issued to you by the National Commissioner or the Minister terminating your appointment as the investigating officer in this case?
Ikhona incwadi oye wayinikwa mhlawumbe umphathi wamaphoyisa noma incwadi ewuye wanikwa ukuthi kuleli cala awusase omunye wabaphenyi. No, I did not receive
Thank
that
you, my
letter.
lord. I have no further
Yes,
questions.
sir. Yes, Mr. Baloyi.
As the court, please, my lord. Warrant officer.
Sorry. Should we go first with, sorry. Mr. Please.
As the court persists, my lord, I don't have any questions for them.
You don't have any questions? Yes, Mnyiki? Mr. Numalo?
But I have no questions, thank you.
Mr. Mtololo?
No questions, madam.
Okay, yes, Mr.
Warrant officer Makubo, you testify that you were not involved in the taking down of the confession of accused number 1, is that correct?
Uthe awuzange ube ingxenye yokuthi ubhale uma umsolo egonyulu.
Ngisho kanjalo.
That is correct.
You were also not involved in the pointings out that took place on the 5th of June 2020, is that correct?
Futhi nokukhomba okwayenzakala nge-5 zika June 2020 wawukade ungasi ingxenye yakhona.
Yebo kanjalo.
That is correct.
And those are the issues that the court is seized with at the moment, so your evidence is not helpful as far as those two aspects are concerned, the taking down of the confession of accused number 1, as well as the pointing out that took place on the 5th of June 2020. The confession took place on the 30th of May 2020. You cannot be of any assistance to the court as far as those two statements are concerned, is that correct?
Lezi zinto ezimqoka ezisilethe la namuhla ukuthi abasolo abaye bayokhomba futhi bagonyuluka ukuthi nge-5 zika June 2020 nange-30 zika May 2020 wena wawukade ungasingxenye yakho lokho kusho ukuthi ubufakazi bakho abukwazi ukuthi kungasiza inkantolo ngalezo zinto ezimbini ukukhomba nokugunyuluka kwakho.
Yebo kanjalo.
That is correct.
You don't know the circumstances under which those statements were obtained.
Futhi awazi nokuthi leza statement zabhalwa noma zatholwa kanjani.
Angazi.
Yes, I do not know.
You testify that you were appointed by the National Commissioner and the Minister
Uthe wena uye waphakanyiswa noma wamiswa commissioner no minister
to be involved in this investigation.
ukuthi uzophenya kule cala.
Yebo kanjalo.
That is correct.
If you say we, who are you referring to?
Uma uthi sa thina usho abobani?
Ukuyimi,
It was myself,
Colonel Telesi,
Colonel Buthelezi,
Colonel Ramohale,
Colonel Ramohale,
also kuba Colonel Geninda by then.
And-
Isikhathi leso Colonel Geninda.
and Colonel Gininda. By then he was still Colonel.
But were you all appointed at the same time?
Nonke
These people that you've mentioned, were you all appointed at the same time?
nakhethwa nonke ngesikhathi esisodwa.
Ngesikhathi esisodwa.
Yes, at the same time, madam.
And when was that? When did this appointment take place?
Bekunini ngayiphi date ngamuphi unyaka?
Nge-18 zika November 2018.
On the 18th of November in 2018.
The evidence of Brigadier Ginina is that they took over as a cold case unit in 2019. What is your comment?
Brigadier Gininda yena uthe bona baye bafika basebenza baqala ukusebenza kuleli cala ngo-2019 njenge-cold case unit.
Mina angiyazi police case unit emaphoyiseni angiyazi.
I do not know the cold case unit in the police service.
But you've just testified about the cold case unit. How can you say you don't know about it?
Manje mawuthi awuyazi cold case unit usho kanjani ngoba bowuphana ubufakazi ngayo?
No, ngibuzwe ngama-case ukuthi anjani ama-case cold case unit, not unit.
I was asked about the type of cases. What type of cases are referred to as cold case units, not the unit itself.
You testify that the cold case unit deals with cases that have been filed. Is that correct?
Kodwa uthe i-cold case unit isebenza ngama-case ekuthi sewafayiliwe. Iqiniso lelo? That is correct.
But Brigadier Gininda outlined the mandate of the cold case unit as working on cases that have not been resolved, not filed.
Brigadier Gininda yena uye wachaza kabanzi ukuthi i-cold case unit isebenza ngamacala angaqedwanga, hayi amacala afayiliwe.
Anje ngichaze le ndaba.
May I explain?
Yes.
Idokodo lisaphenywa. Lisaphenywa.
A docket that is still investigated.
Alibandi lelo dokodo ngoba lisaphenywa.
It's not a cold.
Lisesandleni se-investigating officer.
It's not.
Lisaqhubeka iyaphenywa.
It's not a cold
case.
docket because it's still in the hands of an investigating officer and they're still investigating it. Qhubeka.
I-case ebandayo, i-case esefiling.
A cold case is a case that is on file.
That's why it's a cold case because ifayiliwe.
And that is why it is referred to as a cold case because it has been filed.
Is it your understanding of the mandate of the cold case unit?
Ukuzwisisa kwakho ukuthi cold case unit isebenza kanjani.
Angizwisisi ngiyazi.
It is not my understanding, it's my knowledge.
Anyway, we're not going to enter into a debate into that, but Brigadier Gininda testified that the mandate of the cold case unit is to deal with cases that have not been resolved.
Uthi-ke ngeke
Not cases that have been filed.
ngeke siphikisane ngalokho kodwa uBrigadier Gininda yena uye wathi amacala akusetshenzwa ngawo kwi-cold case unit amacala ayikuthi awaqedwanga.
You mentioned that there were two teams working on this matter regarding the death of Mr. Senzo Meyiwa. Was that correct?
Uthe kuye kwaba namaqembu amabini abekade esebenza ngaleli cala lika Mufi uSenzo Meyiwa. Iqiniso lo?
Ngithe ekahambeni kwe-investigation.
I said
Kwaba nokuhlukana kwaba nokuphezuka kwama-team ayi-2.
I said as the investigation proceeded, then that's when there were two teams where we divided.
And he testified that these teams were of different opinions. Is that correct?
Uthe lamaqembu lawa wayekade ehlukene ngemicabango.
Yebo kanjalo.
That is correct.
This is regarding what?
Benihlukaniswa yini kule micabango?
Sehlukaniswa indaba yesenzakalo se-crime scene eyenzakala eVosloorus.
We were divided by the place of the crime scene of what happened in Vosloorus.
Yes.
Yebo.
Is that correct that there are two theories?
Iqiniso ukuthi nemibono ehlukile emibili.
Yebo kanjalo.
That is correct.
And what are those theories?
Nina nibona kanjani?
How is that going to help us resolve
Resolve
the admissibility of the confession?
yes, that's just based on his evidence. But just one aspect on this point, my lord. You mentioned that you were an investigator in 636, Vosloorus 63610 stroke 2014, is that correct?
Uche wawukade ungumphenyi kwi-Vosloorus case 63610 2014.
Ngumfeni ukhona.
Yes, I am an investigator.
But is that correct?
kodwa iqiniso lokho.
ebeqiniso.
Yes, it is correct.
But is it not so that you were appointed in respect of phosphorus cast 3751 of 2019?
Akusiqiniso na ukuthi wena ubokade uphiwe ukuthi uphenye kuleli cala lika 375 10 2019.
3751 of
Three-
2019.
3751 yaka 2019.
Lelo le docket lika 37 phosphorus 375 stroke 1 stroke 2019
Yebo.
livele masloke siphenya phosphorus 636 of 10 2014
The docket of 375 stroke 1 stroke 2019 emanated as we were busy investigating the docket of 636 10 of 2014.
And is it correct that you are the co-investigator in that case, phosphorus 3751 of 2019?
Iqiniso ukuthi wena umphenyi ophethe la kuleli cala lika 375 stroke 1 2019.
naze liphenya sababili no yimi noPhela Lithele.
The matter is being investigated by myself and Colonel Buthelezi.
So in fact, you are not the investigating officer in phosphorus 63610 of 2014, but you are the investigating officer in 3751 of 2019, is that correct?
Kusho ukuthi wena awusiyena umphenyi waka 636 10 of 2014 ungumphenyi wecala le 375 1 of 2019.
Njengoba sengishilo ukuthi idocket le 375 liphume from phosphorus case 366
Like I said, that the docket 375 1 of 2019 came from the docket of 636
Yes.
of 10 2014.
Yes, and you carried on with the investigation in 3751 of 2019, is that correct?
Waqhubeka ke kuphenyo lika 375 1 of 2019.
yebo.
That is correct.
So it will not be correct to say that you are the investigating officer in phosphorus 63610 of 2014.
Kusho ukuthi akusilona iqiniso uma kuthiwa wena ungumphenyi waka 636 10 2014.
No, amadocket now wonke.
I have
phosphorus case 636 of 10 2014 now wonke.
I have all the dockets 636 10 2014 and the other one.
But Warrant Officer Maku, without belaboring that point, the docket that you are currently carrying, it's phosphorus cast 3751 of 2019, is that correct?
Uthi kodwa idokodo ewuliphethe u 3751 of 2019. Iqiniso.
Njengoba ngisho ngithi ngwaphethe wethu akhona woyi2 in my possession kimi.
My lord,
Akhona.
as I am saying, I have both of them in my possession.
Are you investigating both dockets?
Waphenya womabini.
Mangisebenza le case le 375 angithi ngicala ngibheka ngapha ku 636
As I'm working on the case 375, I firstly refer to 636.
Now, the procedure that you've outlined regarding the arrangements for the confession that you make arrangements with your branch commander, is it documented anywhere?
Leziya inyathelo ewuthe esowukhulume ngazo ukuthi uzokhulumisana no branch commander wakho kunala ukuthi kuye kwabhalwa khona na.
into engayiyela ngayifundiswa into engikhuluma la into engayifundela
That's,
into esuka kimi ngayifundela ngayifundiswa
that is what I was taught. It's not what I just think of or just something that I know. It's something that I was taught.
But what I'm asking you is it documented anywhere?
Uthi umshushisi kunala iyabhalwa khona na.
Hey, Barok, laba basifundisa eklasini phela.
Was-
Yibo abaphethe ama-module.
It was
Eklasini.
documented. It was documented by our lecturers in class, as they are the ones that had the modules.
You agree that the evidence that you gave regarding the arrest of accused number 1 on the 19th of March 2020, that is what you heard from other people. You've got no first-hand knowledge regarding that. Is that correct?
Uyavuma ukuthi ubufakazi obuzwe ngalokhu kuboshwa kukamsola wokuqala nge-19 zika March 2019 yinto eyikuthi uyizwe kwabanye abantu awunalo ulwazi ngakho.
Ngizwe eChlorokop.
Yes, I heard it in Chlorokop when I was called.
Thank you, my lord. Those are the only aspects there.
Yeah, just for my interest, because I'm shocked at what you say. You're saying the minister had originally appointed 40 investigators, 40.
Uthi uminister ubekade yena eqashe abantu abawu 40 ebekade bephenya kwicala. Before us, my lord.
Sir,
Yes.
did you say the minister had appointed 40 investigators?
Uthi inkantolo ifuna ukwazi ukuthi uthe uminister uthe wayekade eqashe abantu abawu 40 abaphenya kwicala.
Uminister njengoba ngishilo la. Ngithe uminister uthe bokunabantu abawu-40 kule case.
As I have said, my lord,
Wabaqosha.
the minister said there were 40 people in this case and he dismissed
All of them?
Bonke,
Bonke.
all of them.
Well, I'll reserve my comments.
Uthi ngeke aphawule
Thank you, sir.
uzawuthula ngalo.
Yes, Mr. Mr.
From the question that were asked by my colleague regarding docket 375 and docket 636, is it the same crime scene?
Uthi ummeli ke kumibuzo ebuzwe umshushisi leli dokodo u636 no 375 la kwenzakele isigameko yindawo eyodwa.
Indawo eyodwa.
Yes, it is the same crime scene.
Is it the same suspects?
Abasolwa bona labo abafanayo kulamacala omabili. No. No.
Will you able to?
Mr.
Sorry.
Mzulu, you're aware
Sorry.
that you're abusing the process.
No.
You are aware.
I'm aware of that.
Sorry,
Sorry.
please.
I beg your pardon.
Yes, is there any other witness you're calling, sir?
No,
No other witness.
no other witness.
Is that number 2's case now?
That's number 2's case. Number 1's case.
I mean, sorry, number 1's case. Yes, Mr. Banwe, we say?
As a court, please, my lord, we're ready to argue. To start with, my lord, we'll ask that the evidence of this witness be struck off the record as irrelevant. The evidence of warrant officer Makubo.
Sorry, before you start, what's the time now?
It's 12:34, my lord.
Okay.
That his evidence be struck off the record as hearsay evidence and as being irrelevant. He can make no contribution on his own admission, my lord. He can make no contribution regarding the issues that this court is seized with. Then, my lord, as far as the argument on the trial within the trial is concerned, we have filed heads of argument.
Yeah, but Mr. Ngobezule, you filed
Lord,
fresh heads, as you said.
yes, my lord, my heads are ready, and I didn't make copies, my lord, because I was thinking that we are going to revise these heads. But may I just stand the matter down so that
Do you
I
want to
can
revise them?
quickly? No. there are certain additional information that I was going to supplement on. May I stand the matter so that I can do copies for the court and for the state?
Mr. Baloi,
That we can do during lunchtime, that we can proceed.
he says he wants to do it before he submits them to court. Am I correctly quoting, sir?
That's correct.
Yes. But he can submit them later, my lord. We can
Sure,
save.
sure, we come back at 2. Sorry, I short.
As the court pleases, my lord, we have an extra copy of the heads. Should the court need a copy?
Yeah, let's see. I told you it's formatted, one of the copies.
Yes, it's the same copy, my lord. We haven't changed anything.
Okay, is that so?
Yes.
Okay, fine. Thank you, ma'am. Yes, sir.
My lord, from the outset, we apologize. Our heads have got words arising from typing errors, and we'll just point out those words as we go along.
Okay, fine.
The structure of our argument will be as follows. We'll start with the issues that has to be decided within the trial, and we will then foreshadow our submissions. We will then set out the law governing those issues. We'll also set out the facts or the evidence in casu that has been tendered. And we will then briefly deal with the defense case. We will then make our concluding submissions. My lord, on page 1, paragraph 1.1, we mentioned that the admissibility of a confession statement made by accused number 1 to Lieutenant Colonel M.M. Mboto on the 30th of May 2020 at Diepkloof Police Station, and a pointing out made by accused number 1 to Lieutenant Colonel Hadebe on the 5th of June 2020, both being justices of the peace or commissioned officers, and a confession statement made by accused number 2 to Lieutenant Colonel Rapadu, also a justice of the peace or commissioned officer, on the 19th of June 2020 at Moroka Police Station, and another confession statement made to Magistrate V. Cronje at the Boksburg Magistrate Court on the 24th of June 2020. Paragraph 2, we point out, my lord, that the admissibility of all these statements is being challenged on the following basis as outlined by Mr. Ramusipili on behalf of accused number 1. And in this regard, my lord, we refer to the record of the 11th of October 2023, page 16, lines 5 to 7 and 8 to 15. Mr. Ramusipili stated the following, and we quote, "My lord, let me clarify from my perspective. My instructions are that he never made any statement," referring to accused number 1. He also denied that he made admission or pointing out. Then he added that he never made a statement. Mr. Ramusipili further mentioned that, my lord, this is the position. As I was explaining, the making of the statement needs to be clarified because he says the statement was brought to him. He was assaulted, coerced to sign that statement. We're not going to read out the reference to the record. The court then asked Mr. Ramusipili, when you say he never made a statement, it means no statement was made by your client. He can make a statement because he was coerced to have made a statement or forced, as you say. Then Mr. Ramusipili responded, that is exactly. Then the court said the following, what do you say, Mr. Ramusipili? Then he says, my lord, this is the position. He made a statement because he was beaten up, assaulted, abused to sign that statement. The court then further asked Mr. Ramusipili, but you say it was never made freely and voluntarily. Then Mr. Ramusipili responded, indeed so, my lord. Then the court had the following exchanges with Mr. Ramusipili. The court then said, for instance, you have told this court that your client was coerced into making a statement. Then Mr. Ramusipili responded, yes. By being assaulted, he responded, yes. Then the court asked any other reason. Then Mr. Ramusipili outlined the following grounds on behalf of accused number 2. Mr. Ramusipili, my lord, let me state individually accused 1, probably referring to accused number 2. He was assaulted, Mr. Ramusipili, over a period of time, court right. Then on page 2, Mr. Ramusipili says, okay, yes, the court then said, accused 1 was assaulted over a period of time. Then Mr. Ramusipili responded, yeah, he was arrested on 16 June 2020. Then the court said, okay, wait, 16 June 2020, Mr. Ramusipili, yes. And the court said, and assaulted. Mr. Ramusipili responded, no, he was assaulted from 19 June. And we emphasize, my lord, the fact that he mentioned that he was assaulted from 19 June. Court assaulted from 19 June, Mr. Ramusipili added 2020. So in other words, Mr. Ramusipili is saying that accused number 2 was assaulted from the 19th of June 2020. Then Mr. Ramusipili mentioned that until he was taken to court. Now, my lord, I had a look at their heads, and I don't want to steal their thunder, but they mentioned they've added a further ground, namely that the rights of the accused were not explained to them, to accused 1 and 2. According to our recollection, my lord, this was not put to any of the investigating team that testified. But be that as it may, my lord, the state will submit that the accused rights were explained at every turn. In fact, it's a recurring theme in this case, like a leitmotif, my lord, that the accused rights were explained to them upon arrest and upon every critical step thereafter, and by the 3 commissioned officers as well. And I saw Advocate Mshololo is contending that the commissioned officers did not explain their rights to them.
Yeah, I just want you to expand on that, because
Yes.
you are saying this was never categorized, meaning that the fact that now it is set in their heads that their constitutional rights were never explained to them. It was
Yes.
never one of the grounds elicited when the court asked Mr.
Yes.
Ramusipili what were the reasons and grounds for saying that these so-called confessions or statements and pointing out were inadmissible.
Indeed, my lord.
Okay.
And Advocate Mshololo further goes in her heads to say that it hasn't proved that the 3 commissioners were fluent in the languages that they use, or in fact, she contends that an interpreter should have been used for accused number 1 and 2 to understand what was being conveyed to them, but this is not a ground that was raised by Mr. Ramusipili. And Advocate Msholo goes further to say that the state hasn't proved that the 3 commissioned officers were in fact commissioned officers, but this is not a ground that was raised by Mr. Ramusipili. In any case, my lord, we will argue that Section 33 of the Police Act states that the President may from time to time by commission appoint officers. So this is a formal act by the President, and we submit, my lord, that the evidence of the 3 commissioned officers should be sufficient where in the state that they've been appointed as commissioned officers. In fact, in the relevant exhibits, FF, GG, and HH, they do state that they've shown their appointment certificates to accused 1 and 2. And in paragraph 1.3, my lord, we make the point that as can be distilled from the above-mentioned grounds as set out by Mr. Ramusipili, both accused deny having made the statements attributed to them, but in the same vein, they allege that they were approached by the police with statements that were already prepared, and they were then assaulted and coerced to admit and sign them. And my lord, we then make the submission that where an accused denies that he ever made a statement, he will have difficulty if he alleges at the same time that he was coerced to admit it. In our submission, my lord, the 2 possibilities exclude each other. Paragraph 1.5, we mentioned that 1 consolidated trial within a trial was held to determine the admissibility of these statements and pointings out. Then, my lord, will then, as indicated, just give an overview of our submission. My lord, in essence, what the accused are alleging amounts to this: that the police decided to concoct a story which they don't read out to the accused. They put this concocted story in their confessions or pointing out in order to make those statements their own, and they then force them to sign those statements. Now, the rhetorical question, my lord, that we ask is this: how will the police have come up with a version that stands in the confession? We ask the rhetorical question: how will the police have known what to write in those confessions? How will the police have known how to tailor the version that is germane to the 2 accused? And we will submit, my lord, that in essence the accused allege that Lieutenant Colonel Mboto, Lieutenant Colonel Rapadu, and Lieutenant Colonel Hadebe, 3 very senior and seasoned police officers, are part of this grossly irregular scheme, in terms of which some unknown police officer completes the confession with all their personal details of the accused and all the information that appears therein, that these 3 senior and seasoned commission officers agree to make a cameo appearance and be used in this nefarious scheme to force the accused to sign the completed pro formas and the confession statements that were never read to them. And my lord, here we must keep in mind that accused number 1 was arrested earlier that day on the 30th of May 2020 before making the confession to Lieutenant Colonel Mboto. Now, the rhetorical question that we ask is, when will his pro forma, Exhibit FF, have been filled out? And when would the police have had the opportunity to concoct a story that stands in that confession, Exhibit FF? Well, we will, as you point out in the heads, will make the submission that Lieutenant Colonel Mboto testified that accused number 1 made corrections when his confession statement, Exhibit FF, was read back to him at paragraph 14.1 of Exhibit FF, which has been redacted. And my lord, we ask this question, is this the conduct of someone who has been forced to make a statement? Can someone who's been forced to make a statement make corrections? And to the question whether he has been assaulted or threatened by any person in order to influence him to make a statement, his answer was, nobody assaulted or threatened or influenced me to make a statement. We submit, my lord, that if indeed he was assaulted, as it is alleged, he would not have couched his answer the way that we have just pointed out. And Lieutenant Colonel Hadebe, on the 5th of June 2020, during the completion of the pro forma, Exhibit GG, in an office at Alberton Police Station, before the pointings out by accused number 1, he causes accused number 1 to take off his clothes of the upper body before and after the pointings out. This we have seen, my lord, as per Exhibit GG in brackets 1, photos 1 to 7, and photos 26 to 21, and there were no injuries detected. Now, this theory, as outlined above, of participation in this scheme of gross irregularities goes further, that the magistrate of Mrs. Cronier's stature similarly acts in a grossly irregular manner and holds out that a pro forma Exhibit JJ and the annexure thereto, the confession statement, were completed and signed before her, when, according to the defense, this was not the case. Accused 2 alleges that he had not had a bath since his arrest on the 16th of June 2020. And, my lord, this fact is contained in the preamble to the confession. Now, the question that we ask ourselves is, did the magistrate now suck this fact out of a thumb? Ms. Cronier had noted in the preamble that the accused had a heart condition. Dr. Hlokwe also states in Exhibit VV in brackets 1, the dental examination, that accused number 2 told him about the heart condition. And we ask ourselves, my lord, is this now a strange coincidence that both mention the heart condition. Now, Ms. Cronje noted on page 5, paragraph C and D, that the accused had a scar on the right side of the forehead and the left eyebrow, both sustained as a small child when his grandmother tried to hit a chicken and the blow landed on his forehead. Now, the accused number 2 considered in cross-examination that he does have these scars, and the question that we ask is, how will the magistrate have known about these scars if the accused did not tell her about that? Then we revert, my lord, to our heads on.
Sorry, I'm sorry to disturb you. What about the reductions? Because as I'm listening to you, have you handled them? Did you refer to the reductions on the documents?
Yes, my lord. Are we talking now about Exhibit JJ?
Yeah.
Yes.
Because according to what I heard, is that there were certain portions
Yes.
of the pro forma which were redacted. So that information, where does it come from, according to you?
Well,
Because according to what you are submitting is that the confessions were baked, meaning they were completed and prepared, and the accused were just forced, assaulted, abused, and told to sign.
Yes.
Does it include even the reductions?
Preamble. Yes. This is in the preamble, and this is not the redacted version.
Oh, it's not the redacted version.
Yes. As far as I have it.
Oh, I see. So it's in the preamble.
Yes.
Okay.
It's in the preamble.
So the preamble did have those reductions, which amongst others, I
Yes.
assume you say, that was incriminating evidence.
Indeed, my lord.
Okay, fine.
And now, in paragraph 2.1, we deal with the requirements for the admissibility of a confession in terms of section 217 of the Criminal Procedure Act of 1977, which reads as follows, and we know that my colleagues are very well grounded in the law. We just putting that on record. Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such a person at criminal proceedings relating to such an offense, provided, and there's now subsection A and B. Subsection A is not really relevant. We're not going to focus on that, but rather on subsection B. Subsection B contains two subsections, Roman figure 1 and Roman figure 2. Roman figure 2 contains a presumption which has been declared unconstitutional in the case of Zuma, which we shall revert to in due course. But it's subsection B, Roman figure 1, that we are going to focus on, my lord. Subsection B reads that where the confession is made to a magistrate and reduced to writing by him, or is confirmed and reduced to writing in the presence of a magistrate, the confession shall, upon the mere production, and here the emphasis, my lord, falls on upon the mere production thereof, at the proceedings in question, be admissible against such a person if the following grounds are met: if it appears from the document in which the confession is contained that the confession was made by a person whose name corresponds to that of such a person. Now, here, my lord, we submit that Exhibit JJ shows that the confession is made by Bongani Ntanzi, which corresponds with the name of accused number 2. And in the case of a confession made to a magistrate or confirmed in the presence of a magistrate through an interpreter, if a certificate by the interpreter appears on such documents to the effect that he or she interpreted truly and correctly and to the best of his ability with regard to the contents of the confession, and any question put to such a person by the magistrate. Now, my lord, on page 9 of Exhibit JJ, there is indeed a certificate by the interpreter which reads as follows: I, Evelyn Tsepiso Muthaping, certify that in terms of Section 217 of Act 51 of 1977, as amended, I have interpreted truly and correctly and to the best of my ability with regards to both the contents of this statement and everything said by the magistrate. And we point out, my lord, that in our submission, the conditions that have been laid down in subsection B, Roman figure 1, have been met. Now, paragraph 3, we point out that the prosecution may lead evidence in rebuttal of evidence adduced by an accused in rebuttal of a presumption under subsection B. We submit, my lord, that the state has done so through the evidence of Ms. Cronje, Mrs. Mutlaping, Sergeant Mohani, as well as Constable Lizering.
Sorry, yeah, I hear you. Just for my edification, there was no pertinent attack on the competence and qualification of Ms. Mtlaping as an interpreter.
No, not
That
at all.
maybe you didn't
Yes.
understand
Yes.
the language, etc., etc.
Yes,
There is
no.
no attack per se.
No, not at all. In fact, there was little cross-examination. I think there was one or two questions that have had nothing to do with her competency as an interpreter.
But further, remember Mr. Ramosepili, when he was adducing the reasons why he says the confessions and the pointing out of number 1, for instance, were not made freely and voluntarily. The primary reason he gives was that this was a complete document. It was brought complete for accused number 1, for instance, to sign. Are you with me?
Yes, indeed. I think he was attacking it on two fronts. He said the accused admits that he signed the preamble, but that the annexure, that is the confession itself, was completed, and then he was forced to sign it at another place in Germiston.
Yeah, Germiston, yeah.
Yes, yes.
And then number 2, does he pertinently say that who forged Ms. Mutaping's signature? Because as an interpreter, she alleged,
Yes.
she testified that she signed.
Yes.
You just read the certificate.
Yes.
Was there any submissions from the defense about that fact, whether in fact they just let it lie that Ms. Mutaping also signed?
No, that was
Was it
never.
attacked?
That was never an issue, my lord. The only thing that was an issue initially was that accused didn't sign it, but then this was later watered down to say, you know, he did sign it to indicate that he asked for, for soap and
Yeah, fine.
and for a bath.
And
Yes, yes.
No, but yeah, pertinently,
Yes,
but
but that was not.
it was never put,
yes.
for instance, that Mutaping must have signed this document somewhere.
No.
Because
that-
her
yes.
evidence is that, as you read the certificate, that she correctly interpreted to the best of her ability the evidence, I mean the questions and what Ms. Cronje
Yes.
was saying.
Yes,
That was just
yes.
left at bay.
Yes, no, indeed, my lord. No issue was taken with her regarding the signature,
Okay.
on the certificate.
Not fine.
Then at paragraph 3.1, my lord, is relevant. It deals with the confession elicited in cross-examination.
Okay.
Then paragraph 3.2, we make the submission that it is opposite to know that the presumption or reverse onus placed on the accused in terms of section 217 in brackets 1, Roman figure 2, that we have just referred to, was found to be inconsistent with the Constitution and declared invalid in the case of State versus Zoom and others, 1995, volume 1, SACR 568, and is the decision of the Constitutional Court. The effect is that where these admissibility requirements are in issue, the state must prove beyond reasonable doubt that the confession is admissible.
Okay.
However, we make the submission, my lord, in paragraph 3.3 that section 2171B regarding a confession made to and reduced to writing by a magistrate or confirmed and reduced to writing in the presence of a magistrate is still applicable.
Okay.
And that such a confession is admissible upon its mere production in the proceedings in question, provided that the name of the person making the statement correspond with the name of the accused, as we've mentioned, that that the person to whom the written statement was made is a magistrate. We've called Ms. Cronje to testify about that. And where an interpreter was used, it must be proved that the person who issued the certificate in terms of this section was the interpreter. We interpreted the statement. Ms. Mtlaping testified and confirmed that. And that the certificate relates to the statement in question.
Okay, but fine. I hear you. And then what about the fact that you say the document, that is the pro forma forms, encapsulated the names of the alleged, they allegedly encapsulate the names of accused number 1 and number 2. Are you with me?
Yes.
I mean, in the form, according to what you were saying.
Yes.
It has got the name, the surname, the address, the ID number, whether it's male or female, etc., etc. That information, what was the submission by the defense? Who furnished that information, in other words? Because the submission, I recall, is that this document came, or the pro forma, it was never filled in their presence.
Yes.
Are you with me?
Yes, indeed, my lord.
Because one of the requirements was that the name of the person whose name appears in the confession corresponds with the name.
Yes.
That's one of the requirements.
Yes. My lord, I also grappled with the same question, and I had a closer look at their heads to see what they are saying, but all that they are saying, they're not saying in so many words that the accused did furnish the information in the preamble. All that they're saying is that the accused does admit that he signed and initialed the preamble, but as to whether with his own mouth he said or he uttered what is stated in the preamble, that, my lord, the defense hasn't really put up a version. The only version that is before court is that of the witnesses, my lord, the magistrate, and the interpreter, that the accused did in fact state what stands in the preamble.
All right.
Then in paragraph 3.4, it is respectfully submitted that Exhibit JJ, the statement made to Magistrate V. Grenier at the Boksburg Magistrate Court on the 24th of June 2020, in the presence of an interpreter as well as the legal practitioner of accused number 2, Mr. Mjiako, to which we shall revert in due course, complies with these requirements, and it is therefore admissible upon mere production. In cross-examination, accused did not, in fact, the accused considered that he was not assaulted prior to making the statement on the 19th of June before Mrs. Grenier. He was only assaulted afterwards, when he was allegedly taken to a dumping area near Germiston and forced to initial the statement. Ms. Grenier testified that she handed the statement to the head of office, Mrs. Dupree, after it was completed. Now, the question that comes to mind is, why would Ms. Grenier allow a document that has not been initialed? I'm talking about the statement itself, the confession itself. Allow the annexure to the preamble or the confession statement not to be initialed, but testify in court that it was initialed in her presence. The suggestion by the defense is that she permitted an irregularity by allowing a document that hasn't been signed to leave her office, then to come to court and testify that it was signed in her presence.
Okay, sorry, Mr. Member, I haven't read your hits, so I'll go along asking this question.
Sure.
You say the submission by the defense is that Ms. Grenier committed an irregularity.
Indeed.
Is that the submission? Not fraud.
Well, there's the import of the...
What is it? Is it fraud or an irregularity?
Well, it's fraud. In fact, it's
yeah, it's fraud.
Yes.
It must be fraud.
Yes.
Because...
just putting it mildly.
Okay. Oh, is that so?
Yes. But that is the effect of what the imputing to Ms. Grenier. We mentioned further that accused denied having made the statement and that he merely appended his signature on Exhibit JJ to indicate that he has complained about not bathing and that he had requested toiletries. But this is in contrast to what was initially put to Ms. Grenier, that accused number 2 denies having signed the statement that includes the preamble. And paragraph 3.5, we mentioned that Ms. Grenier testified that after she and the person with whom she had the interview with, known as Mr. Bongani Ntanzi, had indicated that he was satisfied. Then she requested him to sign each and every page in her presence, in the presence of the interpreter, as well as in the presence of his legal representative, Mr. Mjiako, and we refer to the relevant part of the record. It was also initialed by the interpreter and the deponent, and my lord, what is important is that she stamped these documents. The stamped use is a stamp that was allocated to her in person and sent out to her as a magistrate. She testified that after the parties had left the office, and that includes the interpreter, the deponent, this is now accused number 2, his attorney, Mr. Mjiako, she then handed this exhibit JJ to Mrs. Duplessis, the head of office, who then made copies and handed her a copy later that week. And in paragraph 3.6, we ponder about this fact, my lord, as to this question that immediately after the parties have left her office, she handed the document to Mrs. Duplessis and not the police. Now, the question that we're pondering about is how will now the police, if Mrs. Cronje kept Exhibit J, if she kept this statement, how will now this document have reached the police to force accused number 2 at the dumping area, as they've mentioned, to sign this annexure? And we point out that in Exhibit JJ, it has the stamp of Mrs. Cronje on it, confirming that it is the document that she completed and was signed and initialed before her by the accused. The accused alleges that the document that he signed should have blood stains on it, coming from the injuries from the assault. But my lord, as we have seen when Brigadier Gininda displayed Exhibit JJ before this court, the statement has no blood stains on it. In paragraph 3.7, we mentioned that the interpreter, Mrs. Motlaping, testified that she borrowed accused number 2 her pen to initial and sign the statement. And Ms. Cronje testified that accused number 2 appended his signature after the conclusion of the statement as appears on page 8 of Exhibit JJ.
Yeah,
And-
sorry,
Yes.
just before I forget this. Was it ever attacked, the evidence of Mrs. Motlaping, was it ever attacked that you never handed accused number 2 a pen to sign?
No, in fact, my lord, in
the other way
cross-exam-
around.
Yeah, in cross-examination, the accused conceded that,
Oh, he considered?
Yes.
That?
that Ms. Motlaping borrowed
Who gave
her
you
the
the pen?
pen to sign.
Oh, I see. Okay.
Ms. Cronje testified that accused number 2 appended his signature after the conclusion of the statement, and that portion reads as follows on page 8 of Exhibit JJ, and we quote, "The statement is now signed by the deponent by means of his signature, and the signature of accused number 2 appears below those words. There is no signature at paragraph 8 of the pro forma, where accused number 2 alleges that he signed that portion to indicate that he requested a bath, to contact his family, and to have a change of clothing. Only his initials appear at the bottom of that page. We therefore submit, my lord, that the version of the accused ought to be rejected as false. Then at paragraph 4, we deal with the requirements for the admission of appointees out in terms of section 219A of Act 51 of 1977. There, my lord, we refer to the case of State versus Shiyama, 1991, volume 2, SA 860 is the decision of the appellate division. And there, my lord, the appeal court, Judge Hoekstra, as he then was, he held that a pointing out is a communication by conduct. And such statement by the person pointing out that he has knowledge which prima facie operates to his disadvantage and can constitute extracurricular statement. And again, in Tebeta, 1959, volume 2, SA 337A at 46B to D, again, Judge Hoekstra was part of the bench. Don't know if the same Judge Hoekstra is some almost 30 years earlier. He held that, and we quote, when a person points out a thing, the pointing out is his act and proves that he has knowledge of some fact relating to that thing. And we also refer to other cases of State versus Kumalo, January, and we then, in Kumalo, it was also held that admission is an extracurricular statement. We refer to section 219A, which provide as follows: admissibility
Sorry,
of...
maybe I must confess. The case of State versus January, I was involved in it.
1994, volume
Yeah,
2,
well,
SSCR
1994.
801. Oh, that's...
Yeah.
Yes. I didn't look at the bench.
Okay.
Subsection 1 of section 219A reads as follows: evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall, if such admission does not constitute a confession of that offense and is proved to have been voluntarily made, and that is the operative word, my lord, voluntarily made by that person, be admissible in evidence against him at criminal proceedings relating to that offense. The next two paragraphs are not really relevant. And we turn to page 7, paragraph 4.2. We make the following submission, that the following requirements must be met before an extracurricular statement by an accused is admissible. Firstly, it must be made by the accused, and secondly, it must be voluntary. And we refer to the case of State versus Yolelo, 1981, volume 1, SA 1002, the decision of the then appellate division at page 1009C, where the Supreme Court of Appeal held that section 219A merely codified the common law requirement of voluntariness with regards to admissibility of admissions, And the court then quoted the local locus classicus of R versus Berlin, 1926 AD 459 at 465, where in the case of State versus Berlin, the court held that, and we quote, "The common law allows no statement made by an accused person to be given in evidence against himself unless it is shown by the prosecution to have been freely and voluntarily made, in the sense that it has not been induced by any promise or threats proceeding from a person in authority. That is a principle covering all admissions or statements made by the accused." So the state has to prove that the admission was made free of promise, inducement, or threat from a person in a position of authority, or other threats which may induce a court to find that it had not been established beyond a reasonable doubt that the admission was made voluntarily. And threats imply a causal connection between the threat and the acceptance. It may be direct physical violence or indirect pressure exerted on the accused, and it is always a question of fact, and we refer to the case of Berlin and Mahoti. We furthermore, my Lord, refer to the case of State versus Impeta. We don't seem to have quoted it in the heads, but it's State versus Impeta and others. Yes. Volume 2, the second case of Impeta, 1983. Volume 1, SA 576, and it's the decision of the Cape Provincial Division.
Yeah, Cooper.
Yes, Williamson J, I think.
Williamson, yeah, sorry.
Yes.
I know that case because of the politics of the time.
Yes.
Peter was a prominent ANC member who had gone to Angola, blah, blah, blah.
Yes, indeed, my Lord.
Yeah.
The court then explained the term freely and voluntarily as set out in Section 217 of the Criminal Procedure Act, and held that the word voluntarily in Section 219A of the Act seemed to convey essentially the same idea, and for all practical purposes, there is no meaningful difference between the word as used in Section 217 and as used in Section 219A. And the court further held that in determining what amounts to undue influence, obviously threats or promises are important factors. But the court held that in general terms, any practice is undue which, if introduced into our law or into our code of law, would be repugnant to the principles upon which the criminal law is based. Then the court went on to quote the case of R versus Masinyana, 1958, volume 1, SA 616. It's also the decision of the then appellate division S621, where from the near for JAS then was held the following: the notions freely, voluntarily, sound and sober senses, and undue influence with which the proviso operates are plainly concepts, use them generis or of the same kind. Voluntarily, sound and sober senses and undue influence relate to factors which are calculated to negative the exercise of free will. So in other words, my lord, the court is saying that, you know, all these factors denote basically one thing, and whether the will of an accused was negatively impacted upon.
Yeah, sorry, what is the full citation? Van den Heerser, you said.
Yes,
The judge.
it's Masinyana, R versus
R versus Masinyane.
Masinyana, yes,
Okay.
1958, volume
One.
1, SA 616
616.
at 621, and is the decision of the appellate division.
Okay.
And the court also referred to this case of R versus Kuzwayo, 1949, volume 3, SA 761 at 768. And it's also the decision of then the appellate division. Then the court in Mpeta's case, quoting from Kuzwayo, stated that the test should be put as follows, and we quote, was or was not the confessor's will swayed by external impulses improperly brought to bear upon it, which negative his freedom of volition. He said the test must be couched as follows. Has it been established in the particular instance that the alleged confession was voluntary? It is clear that the confessor's will was not swayed by external impulses improperly brought to bear upon it, which are calculated to negative the apparent freedom of volition. So in other words, my lord, the question that needs to be asked is whether the conduct of the police in this case was calculated to negative the free will of accused 1 and 2. And we will submit, my lord, that the evidence show that the police did not in any way influence the free will of accused 1 and 2. We will remember, my lord, that at some point on the 30th of May 2020, after the accused had made the confession to Lieutenant Colonel Mboto, when he was returned by Constables Munareng and Mapumlo, that Brigadier Gilinda said to accused number 1 that you've mentioned that you want to point out the Inyanga, but go and sleep over it. But please keep in mind the rights that I've read out to you. My lord, we submit that is not the conduct of someone who wants to sway the will of an accused. Then we at paragraph 4.7, we briefly deal with the issues in this matter, as whether the state has succeeded in proving that the requirements of section 217 and 219A have been satisfied. We refer briefly to the judge's rules, and we make the submission, my lord, that the judge's rules are applicable in this matter, and As we've already mentioned, when evidence was given during the testimony of, I think it was Brigadier Gininda, or one of the state witnesses, that at a conference of judges, certain rules were drawn up to render protection to suspects. And it's interesting to see that even in the UK, these judges' rules are applicable. And that the Department of Justice has accepted and published these rules. And we refer again to the case of Mpeta. And we mentioned that Section 35 has now, of the Constitution, has now entrenched some of these rights as fundamental rights. And we mentioned, my lord, that, for instance, if there's non-compliance with Rule 8A, that will be an infringement. Section 35 of the Constitution provides inter alia that an arrested person or detained person should be informed of his right to legal representation, the right to silence, and the possible consequences if she elects to make a statement. And we refer to sub-rule 2 of the judge's rule, which reads as follows: questions may be put to a person whom the police have decided to arrest or who is under suspicion, where it is possible that the person by his answers may afford information which may tend to establish his innocence, as for instance where he has been found in possession of property suspected to have been stolen. And my lord will recall, this is the constant debate that we've always had with the defense, where they insisted that that a formal form should be completed that was handed up. And we mentioned this instance that, for instance, where someone has been found in possession of property suspected to have been stolen, or of an instrument suspected to have been used in the commission of the offense, or where he was seen in the vicinity of the crime when it was committed. In such a case, caution should first be administered. Questions, the sole purpose of which is that the answers may afford evidence against the person, should not be put. For instance, my lord, in this instance, accused number 2 is asked where he was on the 26th of October 2014 when the deceased was killed during the question in the boardroom on the 17th of June 2020. He offers an exculpatory explanation that he was at work at Sibanye Stillwater. Now, the police go with him there to Sibanye Stillwater. They peruse the records and establish that he wasn't at work. And Rule 5 of the judge's rule reads as follows: where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is, my lord, what we are sitting with, that that accused number 2 is arrested for the Nongoma case, accused number 1 for the Tembisa case, and at the same time there's whilst these cases are being investigated, the main case is also being investigated. And this we've clearly seen in the recent case, my lord, in KZN, involving a high-profile musician who was shot, the case that appeared in court last week. Rule 6 it's really not applicable in the current instance as caution was administered. And Rule 7 says a prisoner making a voluntary statement must not be cross-examined, but questions may be put to him solely for the purpose of removing elementary or obvious ambiguities in voluntary statements. For instance, if he has mentioned an hour without saying whether it was morning or evening, or has given a day of the week and day of the month which do not agree, or has not made it clear to what individual or what place he intended to refer in some part of his statement, he may be questioned sufficiently to clear up the point. Then Rule 8 is not really of any relevance here. We go to Rule 9, which states that any statement made in accordance with the above rule should, whenever possible, be taken down in writing and in the language in which it was made. It should be read over to the person making it, and he should be given full opportunity for making any corrections therein that he may wish to, and he should then be invited to sign it. This we've seen a lot with all the confessions. We know that in South Africa we make use of interpreters, and in all the relevant instances, in the case of Ms. Cronje, an interpreter was used, but in the case of Lieutenant Colonel Mboto, Adebe, and Rapadu, all testify that they are proficient in the Zulu language, and hence they dispense with the services of an interpreter. I see that Advocate Mshololo is attacking that point. Paragraph 5.4, it's not really relevant. We go into skip that. Paragraph 5.5, page 10, it is respectfully submitted that the investigation that was conducted in this matter falls within the ambit of the judge's rules that we have referred to above in detaining the accused and obtaining their confession statements, and that the police took great care in ensuring that the accused are informed of their constitutional rights at every critical step, and such explanation of the rights has been documented and handed in as exhibits. For instance, Exhibit LL in brackets 1, Exhibit TT, as well as in the occurrence books, Exhibit KK, MM, NN, PP, QQ, and SS. The next, my lord, we deal with the summary of the evidence presented by the state in a trial within a trial. We're not going to quote our heads verbatim, but just with a broad brush, my lord, we refer to the evidence of the state in the following broad categories. Roman figure 1, the evidence of the cold case unit, investigating team, and the entries made in the occurrence books. Roman figure 2, the evidence of the SWAT members who provided escort duties to the cold case unit. Roman figure 3, the evidence of justices of the peace and the photographers. Roman figure 4, the evidence of the magistrate and the interpreter. Roman figure 5, the evidence of the dentist, Dr. Tabang Hlokwe. Roman figure 6, the evidence of on automated vehicle location, or AVL, by Mr. Michael Jacobus Dupree. Roman figure 7, the evidence of the defense will then be dealt with. As far as the evidence of the cold case investigating team, my lord, they dealt with the mandate of the cold case unit, and Brigadier Gininda testified as follows. Yes, my lord, so the mandate of the cold case unit is to look at all unresolved matters, unlike from what we've heard from Warrant Officer Makubo, that they look at shelf matters. Testify that we look at unresolved matters, or rather criminal cases that are brought to our attention. It basically entails, my lord, cases that have gone cold. In other words, they were not successfully brought to court for prosecution. And he said that is the essence of their mandate, and this was further elaborated upon by Sergeant Mohola, who testified as follows. It is to investigate, my lord, the stagnant, complex, unsolved cases, and also, my lord, to assist other investigators at the stations or other units to come to the conclusion. And it was on this basis, my lord, that the cold case unit then took over the investigation in this matter, as it was on all fours with their mandate. And Brigadier Gininda testified as follows. Yes, indeed, my lord. So the case, it is under Force Lores Case 63610 of 2014. It relates to the murder of Senzo Meyiwa, who was killed on the 26th of October 2014. And we then asked him, when was this unit seized with the matter? He says it was seized with the matter on 18 November 2018, my lord, sorry, 12 November 2018. And this we apologize. I think earlier on in cross-examination he said 2019, it's actually 2018. He further testified that accused number 1 became a person of interest. They started profiling him and discovered that he had an outstanding case, Tembisa Case 217/3/2019. So at the time when accused became a person of interest on this matter, we did what we call a cold case analysis, and that is now the profiling of the accused, or rather the suspect at the time, through the cold case analysis and profiling this particular matter of Tembisa Case 217 was picked up, and amongst other cases in relation to accused number 1. And it was discovered that this Tembisa matter, my lord, and the others that we picked up were all cold cases for some reason. Hence, they were then drawn, my lord, for further investigations, and that is how we came to the issue of a warrant insofar as the matter is concerned. Then there was reference to the arrest of accused number 1 on the 30th of May 2020, and we are on paragraph 7, my lord, where we deal with the events on the 30th of May 2020 and the arrest of accused number 1 by female Sergeant Mohola. She testified that Brigadier Gininda allocated the case docket Tembisa Case 217/3/2019 to her in November of 2019, and she proceeded to obtain a J50 warrant of arrest against accused number 1, Mr. Moses Sibia, in December 2019. That as a result of information, she proceeded to Tembisa. She contacted Constable Butelezi of Ekurhuleni Special Weapons and Tactics, or SWAT, as well as Constable Sadiki. They noticed 3 males were standing in a yard. She effected an arrest assisted by Constable Buthelezi and Sadiki. In fact, Constable Buthelezi testified that he did what he called the takedown arrest. She testified that his rights were explained to him, and that the accused offered to take them to his shack, as she put it. And upon arrival there, they then conducted a search and found ammunition, magazine, and a cleaning rod. Thereafter, the accused number 1 then offered to take them to Vusimusi Hostel in Tembisa to trace the firearm. And
Is it not in Phosphorus?
in Tembisa, no,
Oh, is that so?
in Tembisa, no. And that the search there, or the visit to the Tembisa hostel, did not deliver any positive results, and she then asked Buthelezi and Sadiki to give a private moment with accused number 1, so that she can speak to him. Accused number 1 was seated in the car. She warned him according to his constitutional rights, and she asked him about his involvement in the murder of Mr. Senzo Meyiwa. That when accused number 1 responded to the question which was posed to him, she could see that he was making admissions. She then contacted Brigadier Gininda, who advised that they should meet at First Lores police station before proceeding to Baswitini hostel, where accused number 1 offered to take them to. She asked accused number 1 if he was comfortable with her communicating what he was telling her to, as she put it, her boss, Brigadier Gininda. Accused number 1 responded that he did not have a problem. Brigadier Gininda suggested that they should meet at First Lores police station before going to Baswitini hostel in First Lores, as would like to question him further. They then met at First Lores police station at the parking area. She introduced accused number 1 to Brigadier Gininda, who was a colonel at that stage. And that Brigadier Gininda also introduced himself to accused number 1. Brigadier Gininda then warned accused number 1 of his constitutional rights and asked Sergeant Mukhola to give him a moment with accused number 1 so that he could question him further. And Brigadier Gininda then went into the vehicle wherein the accused was, which was a red Golf. And after the questioning, Brigadier Gininda said that they should perhaps put the issue of going to a Baswitini hostel in abeyance, so that he can start making arrangements for accused to make a confession. Then Brigadier Gininda then indicated that they can leave to the provincial head office in Araton as he was making those arrangements. Paragraph 7.3. Upon arrival at Araton, accused 1 went with her in the office with Brigadier Gininda. They were then joined by Constable Monareng and Constable Mapumlo, and the Brigadier then handed accused number 1 to them, and they went away with him to where he was supposed to make a confession. They went to Deep Leaf police station after the Brigadier has made arrangements. She waited in the office. Paragraph 7.4. Constable Monareng and Constable Mapumlo then came back with accused number 1 after 12 midnight. The brigadier then handed over accused back to her and said that she can continue with the investigation. She indicated to accused number 1 that she will come and fetch him during the day about the information which she has told the brigadier. And as we mentioned, and told accused number 1 that he can sleep on it, and that he must keep in mind his explanation of his constitutional right. And she then took accused number 1 back into the vehicle, and they left Pretoria with Constable Sadiki, Constable Butelezi, and Constable Monareng, and Constable Mapumlo to detain accused number 1 at Vilera Police Station. And upon arrival at Vilera Police Station, entry number 2187 was made on the 31st of May 2020 at 0140 as per the occurrence book exhibit NN, and reads as follows: Transito, arrest Sergeant Mkhola from National Commissioner's Office, cold case investigation with the following: Moses Temba Sibia, CAS 217/3/2019, Tembisa South, and there's also an SAP 14 number. This, my lord, SAP 14 number, as the witnesses have testified, it's the pamphlet containing the explanation of the rights.
Okay.
And says J50 warrant of arrest, no injuries, correctly detained, and Sergeant Mkhola countersigned this entry. And she gave accused number 1 the notice of rights at 0140 on the 31st of May 2020, and a copy of those rights served as exhibit TT. And I've had a look at the submissions by Mr. Ramsepeli. In fact, they are not disputing that the accused had no injuries. I think they're saying that the police assaulted the accused in such a way that no injuries were left.
Is that a submission? No, he was assaulted but no injuries.
Yes.
Sorry, but he's referring to the assaults, the 3 or 4 assaults of the 30th.
Yes, indeed, my lord.
You know, it just struck me. The defense will obviously deal with that. It just struck me that when was it accused number 1 was arrested, when he was at his check, as you call it, he was taken to Phosphorus, and he was taken, I think, to was taken
They
also
first
to
went to Tembisa,
Tembisa,
to the hostel,
to the hostel,
then to Phosphorus, my lord, and from
at the municipal
Phosphorus-
place,
I'm sorry, my lord.
municipal offices.
Oh yes, yes, at Letabong, I think.
Right,
Yes.
yeah. Where, I mean, one would imagine in a municipal office, it has access to the residents of whatever location. And the police chose to go and assault the accused there. But what was striking, which I'm sure the defense will address fully, the accused one, I don't think I'm misquoting him, says that there was a red vehicle. Remember, there was a red vehicle which came and it parked.
Yes.
And then there were police in uniform, etc., etc. But the gravamen of the thing is, he says there were 13 men who assaulted her. 8 plus 5. Those 7 vehicles came there,
Yes.
and he says there were about 8 policemen in those vehicles who were called by apparently Mabena and whoever as people to come and help with the security. And that
Yes.
also in the other 2 cars, or 3 cars. There were 5 other men, and
Yes.
all of them assaulted him at 4 or 3 different occasions.
Indeed, my lord, that is the initial version
That's it.
that was put to
13 men.
to the witnesses, my lord.
Okay, fine.
As it's 3, will this perhaps be...
Oh, okay.
I'm just looking at that portion on their heads quickly, if
Where they,
regarding the injuries.
well, his evidence, I think accused number 1's evidence is that he did have injuries, but he qualifies that by saying that his body was abused and sore, and that we all know that the police have a manner of assaulting you in order that your injuries should not show and be visible.
Yes, indeed, that is what is stated in the heads, and I think they go further and say it was not expected that injuries would be found on
Yeah, after being assaulted by 13 men
on the
in uniform with guns
on the accused.
and whatever.
So court
Carrying
is-
guns, in other words. Not that they assaulted him with guns. Okay,
If we can then adjourn the stage, ma'am.
we are adjourning now.
Is it please?
Okay, tomorrow then.
Ngakhatha nje bafethu zonke izinto sazishoyo ngizontolikela zona kusasa uma eqeda ngaphambi kokuthi abameli baqale nabo ngeinkulumo zabo.
Yeah, you have to interpret for them. Because after, not after, let's say, just do it, have the heads, and do it up to where Mr.
Baloyi is
where he ended now, ne? So that when you start with the interpretation. Yeah?
Yes, sir.
Maybe tomorrow you'll do the same. Day after tomorrow.
yes.
Because it's a lot of information to process.
Yes.
That's why Mr. Balois has even forgotten that there was a red vehicle there. Why, Mr. Numan? Was there a red vehicle there, sir? Which came with 7, 8 men. I don't remember that evidence.
I do remember.
And then it became 8 plus 5. And then they trapped him. At 4 occasions, different occasions. Okay, tomorrow. Right.